Good afternoon. It's Wednesday, the 15th of February at about a little after 1 o'clock. This is House Judiciary Committee. We have 7 bills. We're going to go ahead and start with Delegate Buckle and House Bill 591. If Scott Poyer, Don Lindsay would come on up. We'll hear from Delegate Buckle for 3 minutes, the other 2 people for 2 minutes. And they are the only people signed up to testify. So Delegate Buckle, go right ahead.
Thank you, Mr. Chairman. For the record, Delegate Jason Buckle presenting House Bill 591. I was honored to be asked to bring this bill forth by the Circuit Court Clerks Association. If you're wondering why that would be, it's probably because my uncle was the elected Circuit Court Clerk in Allegheny County for roughly 30 years and gave this wonderful person, my friend Don Lindsay, I believe her first job in the clerk system, who is now the elected clerk of the Circuit Court in Allegheny County. Ms. Lindsay and her colleague from Anne Arundel County are very active in the association. They can explain some of the gravamen of the bill. Everyone says this, so I don't know if you guys play, things that legislators say bingo, as we sometimes do in other committees. This is an extremely simple bill. This is likely the most simple bill, I suspect, that this committee, dealing with the complex issues you see, will deal with this year. I would point you simply to the fiscal note, the second page. The entire gravamen of the bill is the primary paragraph on the second page. Under current law, a court may not assess costs on a person, someone who has a restitution order. They've been wronged criminally or civilly. The court said you get restitution. The clerk's office does not assess a fee for when they go and say, I want to convert this on the record to a monetary judgment so I can actually collect it against someone. They don't assess the fee if you do it in the same county in which you got the order of restitution. So if the Circuit Court for Anne Arundel County gave you the order of restitution, you can file it here with the clerk of the Circuit Court. They don't charge you a fee. However, if the person that you're entitled to get the restitution against happens to live across a county line in Prince George's County or Baltimore City, and you go there to file your order of restitution so you can collect against their property in that county, these fine folks are required to charge you a fee. They detected this anomaly in the law and said that's not fair. It's actually just imposing additional costs on people who've already been wronged. It doesn't make any sense. I think and hope you'll find in your file the Office of the Attorney General has also reviewed it and offered their support and says this is just a glitch in our law that imposes an unnecessary fee for people who've already been a victim at some level or another. And I appreciate the Clerks Association for finding this, bringing it to our attention, and hope that you would move favorable on the bill. And I would certainly yield the remainder of my time for the good folks from the Clerks Association to speak.
Well, she can have 2 whole minutes. Go ahead.
Thank you, Chairman Clippinger and Vice Chairman Moon, and members of the committee for this opportunity to testify in support of House Bill 591. For the record, my name is Dawn Lindsay, Clerk of the Circuit Court for Allegheny County. The clerks of the Circuit Court support House Bill 591 because it closes a loophole in the waiver of recordation fees for orders of restitution. Currently, under Criminal Procedure Section 11-611, the court may not assess costs for recording or indexing a restitution order in the court in which the judgment was issued. That means that someone who receives an order of court that they are owed restitution do not have to pay to have that order recorded by the clerk. However, the current waiver of recordation fees specifically says that it only applies to the court in which the judgment was issued. It does not waive the recordation cost for a case in one county that may need to be recorded in another county. This recently came to the clerk's attention in a case in which an order of restitution was ordered against the defendant in a criminal case, but that defendant had property in another county and the person who was owed the restitution wanted to enter a lien against that property. The victim who was owed the restitution was required to pay to have their order of restitution recorded, only because it crossed county lines. The only change that House Bill 591 makes is to extend the waiver of the recordation fee to an order of restitution issued by any court in Maryland, not just the court where the order was originally issued. The Circuit Court clerks hope you will give a favorable report on House Bill 591, and we would like to thank Delegate Buckle for sponsoring this bill. Thank you for the opportunity to comment, and I'm available if you have any questions.
Thank you, Chairman Clippinger, Vice Chairman Moon, and members of the committee. My name is Scott Poyer. I'm the clerk of the Circuit Court for Anne Arundel County, and I also request a favorable report on this bill. And I also thank the chairman, and I thank Delegate Buckle for sponsoring this bill. Thank you very much. And I'm available for questions.
Questions? Delegate Kaufman.
Just very briefly, Mr. Minority Whip, I have a question because you're an actual lawyer. I just play one on TV. Could you explain in English what it means when somebody is having their restitution order recording, does that mean it's just on file at the courthouse, or what does recording mean in this?
Yeah, that's exactly what it means, is that oftentimes in order to levy upon real or personal property that you may be the owner of, located in a particular county or jurisdiction, there has to be an indexed or recorded judgment. So the restitution order, when you record it, has the same legal effect as a judgment, as if you had been sued and someone had entered an amount and said, you owe this person $10,000, and then they don't pay you the $10,000, and you say, but you own some property over here, or you have a bank account that's maintained in a particular county, I can go and levy. I can get that money garnished, so to speak, or levy against the property. And that's what the recording of the judgment means. You go to these fine folks, they enter it as a valid legal judgment, essentially, against that defendant, and then it gives you the ability to get your restitution if the defendant doesn't just willingly pay.
All right, thank you for the education, Delegate
Sure.
Buckle.
Thank you.
Further questions for the panel? Seeing none, we thank you all very much. That concludes the testimony on
Thank you
House
very
Bill
much.
591. We'll go now to Delegate Grammer and House Bill 589. He has two other bills in two other committees, so we're going to see how long this takes. And we'll hear from him and from Christopher Sass, or Sassy. Do you have somebody from the Troopers Association?
I
No.
believe someone from the Troopers is here, yes.
Christopher Sass. Oh, boy. Okay, well, you go ahead for 3 minutes, and we'll see if he shows up. That'll be
All
fine.
right, thank you, Mr. Chair, Mr. Vice Chair, members of the committee. For the record, Delegate Robin Grammer here to present House Bill 589. House Bill 589 establishes alternative expiration and renewal periods for a handgun carry permit issued to retired law enforcement officers. The public safety article sets the renewal period to the last day of a permit holder's birth month, 2 years after the date of the permit issued. This bill changes the period for retired Maryland law enforcement to 7 years after the first issuance of the permit and 5 years thereafter. This is a simple quality of life change for retired law enforcement that recognizes their years of service, good standing and training, and hopes to keep them in the state of Maryland. Be happy to take questions, and I'd ask for a favorable on House Bill 589.
Are there questions for the delegate? Christopher Sass, are you here? Come on up. We'll hear from him for We'll hear from him for 2 minutes, and then we'll take questions, actually. So we'll go from that.
Sorry, I'm late. I had traffic issues.
You're fine.
Good afternoon, Chairman Clippinger, Vice Chairman Moon, and members of the Judiciary Committee. My name is Chris Sossi. I'm a retired state trooper. I'm the Vice President of the Maryland Troopers Association. I retired in 2012, 28 years of service. I'm here to testify in support of House Bill 589. The Maryland Troopers Association supports this proposal to create an alternative expiration and renewal periods for handgun permits for retired law enforcement officers. As state troopers, even after retirement, we continue to serve and protect the people of the state of Maryland. The legislation has potential to create a simpler process for handgun renewal for retired troopers. Our retired police officers, in good standing, appreciate the trust from Marylanders and the consideration for this renewal process. We hope the committee sees the benefit that this can have for members of the Maryland State Police and members of the Maryland Troopers Association. Thank you for your time and for your service. We hope for a favorable report on House Bill 589.
Questions? Delegate Cardin.
Thank you, Mr. Chair. Just real quick to the state trooper, the retired state trooper. Are you required to have any continuing training or use of your handgun in order to maintain your status with your permit?
No.
You're not?
No.
So this wouldn't change any additional requirements for training?
No.
Okay, thank you.
You're welcome.
Are there further questions for the panel? Delegate Valentine.
Thank you, Mr. Chairman, and thank you both, Delegate and Mr. Sossi. The question I have is for individuals that already have their permit, would this then take effect with their next renewal for those already in possession of?
Yes.
The timeframes, the 5-year period would take effect upon their next renewal?
Yeah, because once you've issued the permit is good for however long the permit's good for. So this would apply on the new permit and every time thereafter.
Thank you.
Thank you.
Any further questions? Seeing none, we thank you all very much. That concludes the testimony on House Bill 589. We're going to go now to House Bill 610. We're waiting for members of the Judiciary to join us. Unless they're here, I don't see them. They're not. So, okay. We're going to go to House Bill 610. And if anybody from the Judiciary is watching us as they try to see what's going on next, the next two bills I have, apart from the Judiciary bills, have quite a few witnesses. So, just saying. All right. Delegate Cardin, it's you. So go ahead for 3 minutes.
Thank you very much, Mr. Chair. And just, this is House Bill 610. I'm John Cardin, and I'm asking for a favorable report on this. This came out of a client situation that I had where there was clearly a situation where a interested party was the signer, one of the witnesses to a will, and litigation ensued because of that as to the question of whether they created undue influence on the testator, the person whose will it was. I have spoken with, what the bill does is it says that an interested party or a personal representative cannot serve as a witness on a will. That's what the bill does. And I have talked to a number of family law, elder care law and estate and trust law lawyers, all of whom universally say it is their practice to not have interested parties be a signer of a will, because you don't want it to look like there's a conflict of interest where they might be getting the house and they're also the ones signing the will saying, yes, this person did this knowingly and voluntarily without any undue influence. And the issues, and they all say that they would never practice that. However, because of COVID and because there's sometimes hard to find, you want to leave that option open. Well, to me, it seems like if it's never good practice to do it, why are we allowing people to do it? Now, I can understand for personal representatives who may not have an interest in the will to be able to be a signer if necessary in exigent circumstances. But I don't think there's ever an appropriate time for a interested party who's going to get something from the will to be the person saying that the will maker is doing this knowingly and voluntarily without my influence. It just doesn't make sense. It's bad practice. It shouldn't happen, and we should make that against public policy. The question you have is to balance whether you want convenience versus you want to make sure that you create no demonstration of a conflict of interest that will then possibly create litigation. And for those of you who don't practice estates and trust law, I learned this just recently, that litigation over fraud or conflicts of interest could cost in not the thousands, but the tens of thousands of dollars, which is oftentimes more than the estate might be worth. And so everybody winds up losing if you have this. So why do we create this situation? We shouldn't. And that's why I put the bill in.
Are there questions for Delegate Cardin? Seeing none, thank you very much. We do have one person testifying in opposition. That's Deb Howe.
Good afternoon. I'd like to thank the committee for your time. My name is Deb Howe. I'm a local estates and trust attorney, and I'm here on behalf of the Maryland State Bar Association Trust and Estate Council in opposition to House Bill 610. We oppose House Bill 610 for 3 reasons. The first is that it inserts ambiguity into the code. The second is that there are unintended and far-reaching consequences. And the third and final is that the issue that is being targeted by this bill is adequately addressed under existing Maryland law. With regard to the ambiguity, the change would prevent personal representatives or interested persons from witnessing a will, as Delegate Cardin just mentioned. The problem is that the identity of a personal representative and an interested person is not known until the will is probated, when the court appoints the personal representative and the interested persons are determined. So, for example, if I were to have a will where I leave my assets to my nephew, and then go on and say, if he predeceases me, I leave my assets to my friend, Who that interested person is, whether it's the nephew or the friend, is not known until I die and my will is probated, because I don't know if he's going to predecease me. So there's an ambiguity about who is actually precluded from witnessing a will in that case. Same with the personal representative. Is it the person named or the person, a backup or some other person whom the court appoints? So there's an ambiguity there that is not addressed by the proposed legislation. The second is the unintended and far-reaching consequences. I agree that as a best practice, my wills are not witnessed by people named in the wills. I completely agree that as a best practice, that is the case. Unfortunately, a lot of wills that come across my desk on the administration side were not signed under the best practices. It's, a family comes together to prepare a will. It's a highly personal project, and they often want to share that with family and friends, oftentimes the same people named in the will, whom they call in to be the witness. So the reality is this would very possibly invalidate a large number of wills. And then also because of it's an overbroad, it would throw out the entire will rather than a specific bequest that involved the interested person. That is why the Estates and Trust section of the State Bar Association opposes 610. Thank you so much.
All right, so I see the sponsor. I got you. No, but hang on a second. I'm going to go to Delegate Kaufman. I have a couple questions, and then we'll go to the sponsor. Delegate Kaufman.
Are you sure you don't want to go first, Mr. Chair? My question is...
I'll know in a couple minutes, but that might be the theme that I'm going to be going with here in a moment, but go ahead.
My question is, I'm confused. I just did my will for the very first time a few months ago. And you stated eloquently in your testimony, ma'am, that, people may not know until the will is read, who the beneficiary is or who the personal representative is. And that's just confusing to me because my lawyer, who helped me draft it, knows who I'm leaving everything to and who the backups are that, if John Doe dies, who I'm leaving it to if people die that I initially wanted to leave things to. So I guess I'm a little bit confused as to why you asserted that people wouldn't know when, in fact, it's, my lawyer knows and it's spelled out in the will way ahead of time. So if you could enlighten me, please, that'd be great.
Thank you for your question. Absolutely. The terms personal representative and interested persons are defined terms by the code. And so although you name someone to be the personal representative and the backup, as well as someone to be the interested person and receive the estate, those individuals are just nominated into those roles. You won't know who technically is the interested person or the personal representative until the estate is probated. So, for example, if the first personal representative you named for whatever reason is not appointed, they actually would not be precluded under this statute from witnessing the will, whereas the backup would. So that, because we're talking about defined terms, and those are the individuals who are referenced in the statute, we don't know exactly who that is until probate.
So let me just make sure I'm understanding, and I promise this will be my last question, Mr. Chair. So what you're saying is, just to make sure I'm understanding, is that if I appoint Chair Clippinger as my personal representative, but I end up outliving him, and so they have to go to the backup, you don't know who of your personal representatives and who of your backups will still be living when you pass away? Is that what you're trying to say?
So what I'm saying is, in that scenario, the chair actually could have witnessed your will. But at the time you signed it, you probably assumed that he was precluded. And in fact, if you had had the backup sign as the witness, that would have invalidated the will under the proposed legislation.
Okay, thank you.
I'm going to pass for a second, and I will go to Delegate Cardin, then Bartlett, then Phillips.
Thank you, Mr. Chair, and thank you for your testimony. And I was aware of this opposition. I understand it. Dealing with your last point, if you just made the section of the will that bequeathed whatever it was to the interested party invalid, that would satisfy your issue there, would it not?
So there is actually, under Maryland law, that is how this is addressed, if it can be separated, leaving an intelligible document. And that's the Gortez v. McNally case. That would address one of the concerns. I think that the issue with that is that the application of that might be a little bit difficult. Right now, it's done in the courts through an undue influence case, as you mentioned, rather than as a statutory fix. I have not explored how that would work as a statutory fix, but that is currently what exists under Maryland law.
And thank you. And the final question is referring back to Delegate Kaufman. If you know that you have a personal representative and a backup, and then a third backup, and then a fourth backup, why can't your attorney just suggest none of those people serve as witnesses?
I agree that that would be an option for the attorney to do. The ambiguity in the law remains, though, because who those individuals are who are precluded are simply not known just looking at the statute, especially if we end up dealing with a situation where you have designated a class. For example, I leave the residue to my grandchildren. You know, in that case, we don't even have names. So it's potentially a very broad group, or, you know, I name this person to designate my personal representative. I mean, that's an option under the code and could create even more ambiguity about who is precluded from witnessing.
Thank you.
Thank you. So I do not practice in this area of law, so I'm just going to go on the face of the bill, okay? Would you agree that interested party and interested person are defined differently?
I would have to look at what is referenced in this
well,
section.
you've made a couple of references to interested person, and I understand the definition of interested person. Interested party has a much broader definition, and it's not limited simply to someone who may be, it's not limited to what the statute defines. So I wanted to kind of drill down to what's actually in the bill, which is interested party. And do you see a difference there?
Potentially. I agree that interested person is very narrowly defined in the context of a state administration. Off the top of my head, I'm not sure what the definition for states would be of the interested party.
Okay, so with that said, we'll both agree that we're not sure what that definition is. I have a little bit of a question with respect to, you were saying that sometimes the individual is not even defined or named because it's children who are coming forward. Well, they wouldn't be available to sign as a witness anyway. I thought we were talking about credible witnesses to witness the will as it exists. So we're not talking about, you see my dilemma?
So the class, naming a class of beneficiaries doesn't necessarily mean they're not currently in existence. So I could say my nephews and nieces, even though all my nephews and nieces are currently in existence over the age of 18 and could possibly serve as credible witnesses. But I do see what you're saying, but it doesn't preclude this issue from arising.
One last question, if I may, Mr. Chair. So as a policy, I think what I'm hearing is, as a policy, you agree with the policy behind the concept of the bill, but you might not agree with the mechanism in which the bill, the language of the bill. Would you like that to be more defined? Is that what you're saying?
I agree that as a best practice, I do not allow, for example, a beneficiary to serve as a witness for a will that I have in my office. But there's a lot of best practices that, for very good reasons, are not institutionalized into the code. And I think that bringing this into the code would create scenarios where wills that were not the product of undue influence are invalidated just as a matter of course, because, you know, a family member or some other interested party was brought in to act as a witness.
Gotcha. Okay. But going forward, after this, if this bill passes, one could prevent that by not allowing an interested party or a personal representative to sign, maybe to be a witness on their will. So you could prevent it going forward. I mean, the bill isn't retroactive, right? Okay. So it's not retroactive. It's only going forward. So the practice would be never to have anyone who is listed in the will to be a witness or the personal representative.
So actually, abiding by the law, the letter of the law, I think would be difficult because of the ambiguity I talked about. But assuming that we modified and rose past that, you then come to the issue of, especially smaller practitioners who are general practitioners or individuals who are preparing a will without the assistance of an attorney, who often, like I said, do it in a family affair, bring in a family member to sign as the witness. Those are the wills that I would be concerned personally that would be invalidated. I mean, this is not going to affect any of the wills that I prepare in my practice, but it's going to affect the wills that people prepare on their own, I think, most dramatically, and invalidate those.
I think you just hit the question I was going to ask,
Okay.
which was really in terms of your practice, a couple of questions. Number one, how often have you seen an issue of undue influence in the preparation of a will? Help me to understand the significance of this and the impact.
Undue influence is not rare. It is a real issue, and it is addressed under existing Maryland law. Part of my practice is to litigate estates and trusts matters, and a very common grounds for litigation is undue influence in a will. And sometimes I've actually seen the person influencing as a witness. Honestly, it's rare, but I have seen it. And Maryland in Moore v. Smith actually laid out some factors to consider about whether there is undue influence. And one of them is whether the individual assisted in essentially creating or having the will executed. So this is addressed when addressing undue influence. This is squarely within that element of undue influence. But it does definitely happen. And of course, I mean, I have a litigation practice that addresses it, so maybe I see all the cases that come forward. But it is an issue.
So would you suggest that there is perhaps a need for a statutory fix so we reduce the issue?
I do not see the need for a statutory fix because when I see undue influence cases come my way, the answer is that this is a piece of, this person serving as a witness is in the minority of cases. Usually it's the person brought the testator to the attorney, was controlling meds, et cetera, and influenced him that way. It's more rare that they're actually serving as the witness. But if they do, in fact, serve as the witness, like I said in the Moore case, that is actually a piece of evidence that the court can consider when determining whether there was undue influence in the preparation of the will. And then one step further, the solution that's currently in place wouldn't invalidate that will. Instead, if that gift to the influencing party can cleanly be removed from the will and leave an instrument that is intelligible, that the rest of the testator's intent would be honored.
And if I could, one more question, Mr. Chair. How often do you see wills that are prepared by a family member or the family member themselves prepares their own will versus using an attorney?
I do not have a percentage off the top of my head. I will say it's much more common that someone will go to LegalZoom or even have an attorney prepare a will for them and then take it home to sign on their own. I've even heard of instances where attorneys will go to a person's home and pull in a neighbor or friend as a second witness. And those are the instances where I've seen, especially with the personal representative serving as a witness, because oftentimes the personal representative is a close agent or fiduciary to the testator, and they would want them involved in that process. That's the most common scenario that I see. However, I really only see those in my practice with people who are coming to me to redo their estate plan and bring me their old wills. I see it there. I also see it when I administer. If a family comes to me because mom or dad has died and they bring me the will, I do see it there, but it's not extremely common that I see it. Often those people are going to the Register of Wills without a representation to administer the estate.
And when that happens, what would the impact of this be often on those types of situations?
So in the situation where the personal representative or other beneficiary or interested party is a witness, that will is just not a valid will. It may not be probated.
Are there further questions? Delegate Taylor, please.
Just to add on, just to add more clarity, I just really want to paint a picture here so it's clear. I'm in the business of taking care of seniors. A lot of veterans, a lot of homebound seniors. So let's just take my mother, for instance. She's homebound. I'm her only daughter, and she has assets. And I'm encouraging her to put a will together, because I know that she wants to leave some of her assets to her church, to her sorority. Of course, I'm in that line as well, right? So we're homebound. So I have gone to LegalZoom, which I've done, and created a will for her because she's homebound, but she still has her wits about her. And I am the witness to her will. So under this scenario, once my mother passes and her assets go into probate, then I, in a sense, have invalidated her will. So what I needed to have known in advance was the new policy, was that I needed to know that I should have had somebody else in the room with me, or as one of her CNAs, or somebody else that was her caretaker to be that witness. So
You would have to have two other people, because a will must have two credible witnesses. Neither of them, if I'm reading this legislation correctly, could have been the personal representative or interested party. So yes, that will would be invalid under the new legislation.
thank you.
Further questions for the panel? All right, seeing none, we thank you very much, and that concludes the testimony on that bill, on House Bill 610.
Thank you so much.
We're now going to go to Delegate Conaway and House Bill 481. I'll ask for Stephen Kroll, Ivan Bates, Sarah Matthew, and Chanel Branch, former Delegate Branch, to come to the witness table, testify in favor. I know there are 4 seats. We're going to have to get you an extra chair and work it out. Do you have a delegate, former Delegate Branch? Sarah Matthew? We have the extra chair? Okay, that's fine. So we're going to begin. We'll start Delegate Conaway for 3 minutes, everybody else for 2.
Thank you, Mr. Chair, and thank you, Judiciary Committee, for having me here today. I'm Delegate Frank Conaway, Jr., here to introduce House Bill 481. This is a criminal law wearing, carrying, or transporting a handgun penalty bill. I'd like to dig right into the bill and go to page 2, line 14 through 18, which explains to you if a person has not previously been convicted under this section. So this is not a mandatory minimum bill. This is not a first-time out bill. This is a repeat offender bill. And what this is going to do is increase the maximum time that can be given from 3 years to 5 years. I look at this as a public safety issue, and we want to help slow the flow down to the pipeline to prison. You might want to think of it like this: if someone is going down that pipeline, it might be better for them to get 3 days or 3 months time out than to have to serve 30 years time in. And if we can save someone, that's a good thing. But we need this right now because bystanders are being hurt, innocent mothers, parents being killed. The mayor of Baltimore has sent a letter, and Congressman Fumi has also sent a letter, and he's thanked me and you all too. And with that, I'd like to turn it over to State's Attorney Bates.
Good afternoon. My name is Ivan Bates. I'm the State's Attorney for Baltimore City. Chairman Clippinger, Vice Chair Moon, and members of the committee. When I talk about this bill, I think about a couple of things. One, I think about the citizens in Baltimore City. There have been numerous reports and data that talks about what's going on, and basically 77%, according to Johns Hopkins study, says that handguns or legal handguns are the #1 problem in Baltimore City, one of the main things we need to talk about. We've had murders, 300 every single year in the past 8 years. We tried a number of things. Let me give you a couple stats from the State's Attorney's Office. In 2020, there were 1,641 handguns that were handled throughout the State's Attorney's Office. Only 401 were guilty. 2021 was 2,769, 926 guilties. And 2022 was 3,096 handguns, wear, carry, and transport, all of these, that's what this bill would focus on. 1,041 guilties. So what that clearly shows is that we've gone from 1,600 guns in 20 to over 3,000 guns in 2022. So what are we doing about it? Well, we already have the law that talks about PS 5-133 that says if you're between 18 and 20, you can go ahead and face 5 years in jail. But common law 4-203 says if you're older, that you can receive 3 years and $2,500 fine. That's the maximum penalty. I'm asking that this law now go to 5 years. There's a couple of reasons why. But for me, I want to think today about a young lady named Maya Morton. And this is about the victims that we see in Baltimore City. And to me, this case typifies these guns. So many young people, so many people are carrying illegal handguns in Baltimore City. Miss Morton was driving down the street, heard some shots. She begins to drive her car. She has a 3-month-old in the car, 3-year-old in the car, and she takes off. Individuals run out, they have guns on them, and they just start shooting. These individuals are all carrying these guns. The weapons are there, and these are the types of things that this bill hopes to do to say there are severe penalties, and the penalty can be harsh if you're going to carry your weapons.
Mr. Bates, I'm going to need you. Thank you. You'd like to go next? Ma'am? Whoever would like to go next is fine.
Thank you, Chair, Vice Chair, and members of the Judiciary Committee. My name is Chanel Branch, and today I come in support of HB House Bill 481. I don't want to repeat a lot that was already said, but I just want to be able to come in support because I believe that this bill will simply align penalties and fines equally across the board. In addition to being another tool that we'll be able to use to show that consequences in such crimes won't be tolerated when they're committed. Living in Baltimore City with over 300 murders every year, this just would just show that we're moving in the right direction. I'm a mother who also lost a child to gun violence, and had this bill been passed years ago, I may not be sitting before you now expressing my concerns about why the tougher penalties are necessary. I know that this bill may not mean a lot to some, but it is huge to me because it does show that we are simply just sending a message that we're tired and this will not be tolerated anymore. We live in a city where there are over 300 murders, and we need something, if not a little bit, just to show that we're tired, we're fed up, and enough is enough. So this is not a mandatory minimum sentencing bill, but it does put another tool in the toolbox. So today, I do know most of you, and I know that you are fair, but I'm just also coming to you and just asking you for a favorable report. Thank you.
Okay. Good afternoon. My name is Sarah Matthews, and I just want to tell you briefly a little about my background. I'm here representing older adults and underserved communities in Baltimore City. I'm here because we as older adults who are aging in place in our homes, in the community, the small streets, the drug dealers are hiding their guns and their drugs in our yards. They are threatening that if we call the police and report them, it will be the last time we make a call. We are afraid to go out of our house because guns are very accessible to young people. We hear, as older adults in our home, cemeteries, guns, cemetery guns, street gangs guns, repeat offenders guns. We are asking that you consider passing this bill because we would like and hope and pray that you will be proactive in your legislation and not reactive. And when you carry a gun, I would like for us to think about the intent. It's certainly not to demonstrate show and tell in Ms. Matthews' social study classes on Friday. I worked for the Maryland State Penitentiary, I worked for Coppin as an adjunct professor, and I taught at the Maryland State Pen. There were really rehabilitations. I'm asking you to please pass this bill to make my life, my older adult friends, safer in Baltimore City. Thank you so much.
Thank you. Mr. Kroll, are you a Me Too, or would? That's fine. If former Delegate Branch appears to change chairs, so that's fine. If we can move, there we go. Mr. Kroll, 2 minutes, please.
Good afternoon, Mr. Chairman, ladies and gentlemen of the committee. My name is Stephen Kroll. I'm the State's Attorney Coordinator for Maryland and Executive Director of the Maryland State's Attorneys Association, here in support, yes, support, of House Bill 481. This bill got the unanimous support of all 24 elected state's attorneys. It is a statewide problem, not just a Baltimore City problem. Guns affect everyone. You know how hard it is to get 24 people to agree on anything? You know how hard it is to get 24 electeds to agree on anything? All 24 agree in support of this bill. And because of that, and because it's a state problem, not just a city problem, we're asking your support in House Bill 481 and ask for a favorable report. I know that I want to express my thanks to Mr. Bates for bringing this bill forward. Delegate Conway, you also for bringing this bill forward. And again, we ask for a favorable report. I know that Mr. Bates and I are happy to answer any questions.
Thank you very much. Very briefly, while I know we have a number of people who are in the room also who are here to testify in opposition, I'm getting questions about who's going to go first. Very quickly, after this panel, it will be Mr. Armsbaugh, Mr. Finnessy, Ms. Leno, Ms. Emanuel, Ms. Robinson, and Mr. Pennack. With that, we'll take questions. We'll start with Delegate Munoz, then Erica, and then Grammer.
Thank you, Mr. Chair. Thank you to the sponsor for bringing this legislation forward. I had a couple questions. Mr. Bates, I believe in your testimony you brought up the issues with illegal guns multiple times. Is that your position?
Illegal guns, yes.
Yes, sir. Okay.
Yes, ma'am.
And to the sponsor, does this legislation specifically pertain to the illegal use, carry, wearing, open carry of illegally obtained firearms?
Yes, and you should note also to receivers that are printed, the printed receivers are now included in gun legislation.
Thank you. And what about lawfully obtained firearms?
No. No.
That's not covered
Well,
in this?
as long as you have your wear and carry permit.
Okay, so you wouldn't be covered by this?
Right. You just can't, just because you own a firearm doesn't mean you can walk around the street with it. Even if you legally own it, you have to have permission.
If you have the right permits?
Yes.
It wouldn't be affected by this particular legislation. And then another question for Mr. Bates. So there's a bill in this session to make theft of a firearm a felony because it's currently a misdemeanor. Do you have a position on that as regards to this issue and what you're dealing with in your city?
If I can. I think due to the nature of this bill, we should stay on the topic, so I would refer to one subject rule. Chairman would agree?
Yeah, and we're going to stick to the bill that we've got in front of us. That bill will be coming to traction, so we'll take those questions then.
Thank you so much.
All right, that's fine. Delegate Erican, Grammer, and then Phillips.
Thank you, Mr. Chair, and thank you, Delegate Conway, for bringing this really important bill forward, and to former Delegate Branch. I'm so sorry that you even have to be here to do this, and so sorry for your loss. I know I speak for our whole committee. We really wish that you didn't have to be here today for this. My question kind of dovetails off of Delegate Munoz's question. We've had like 100,000 people get permits to wear and carry, like you mentioned, and I know this bill doesn't directly deal with them on purpose, but I'm trying to think of a scenario where, you know, a single mom, she has her carry permit, she accidentally parks on state property, somebody hits her car, police find out she has her firearm, she's not in the location where she's technically supposed to be. Would this bill increase the penalties for her?
Well, I can tell as a state's attorney, if that case came to me, I don't understand necessarily why we didn't want to prosecute that case.
Okay, so that's not the intent.
That's not the intent. you legally purchase the gun. Sometimes people, you have a legal, and you purchase it properly.
Right, and you're the
And you have
carry
a permit.
Yeah.
And say you just didn't store it properly, it's in your car, it's not stored properly, that's not the type of case we're trying to prosecute. We're focused on individuals of having illegal handguns, do not have their permits. My suggestion is just go get your permit.
Yeah.
If you just go get your permit, if you just purchase it the proper way, I enforce the laws that you make, and that's all I want to do with this bill.
Okay, and Mr. Kroll, have you heard anything about the other state's attorneys and a scenario like that where it's an accidental carry-on to state property, for example?
I have not heard from them, but I can tell you from my experience, that it'll be consistent with what Mr. Bates said.
Okay, all right, thank you so much.
Thank you, Mr. Chair, and thank you all for being here. So the first question I had, the young lady mentioned intent, and it speaks to Delegate Arakan's point. So just to be clear, if someone goes to the range and they shoot a .22 and then they leave and then they forget their guns in the car, technically that person could still be prosecuted under this law.
Was the gun purchased properly?
Yeah.
And was the gun, how was the gun, was it in this carry case?
Yeah.
And it's in the car?
Yeah.
Why are we prosecuting that case in the first place?
I understand that question, but there was just a Supreme Court case in Maryland where this question for this law came up, and they said it's strict liability. It doesn't matter. If you're carrying, you can be prosecuted. And I think my question is, are you okay with maybe some uncodified language we can express? You know, we don't want Joe, the guy who shoots his gun at a .22, to get prosecuted, because these kind of things do happen where somebody makes a mistake and then they're facing 5 years.
Yeah. I'm okay with that. The whole focus and intent of the bill isn't to go after individuals who legally purchase their handguns. It's to go after individuals who are legally having handguns.
Sure. My second question is this. You've talked about the math about how a criminal charge, once applied, ends up being redacted. Current 3-year sentence, how much time does a person actually serve, even if they're convicted, currently?
So because of Justice Reinvestment Act 2016, and for the record, I really like the law, but it's only 8 months. 8 months is basically a time served sentence. By the time you're arrested, by the time you go to district court, maybe circuit court, it's 8 months time served, you're going home. On 3 years, because you only have to serve 25% of your sentence on the Justice Reinvestment. However, with 5 years, now you're looking at maybe 14, 15 months, which could potentially show that your penalty is a little more harsh. Now, that's important because when I look at Johns Hopkins, they had a study reducing violence and building trust. One of the things they talk about in communities most impacted by gun violence, they talk about that, but they also talk about how we must focus on gun violence, and in focusing on gun violence, the strategy will require coordination amongst police, prosecutors, and collect evidence and warn identified individual about harsh sanctions if they do not stop the violence.
Right.
Well, 3 years is not a harsh sanction because you're doing time served.
Right.
5 years is. I know what the data says, I get it, but we have to apply the data to the people who are carrying guns. Right. Harsh sanctions, understanding that 5 years division and correction, that's a more harsh sanction.
And that kind of gets to my point, because we're not actually talking about 5 years. We're not even actually talking about a year. If we pass 5 years, these people aren't going to get a year. So, you know, this issue's been discussed more broadly by this committee and the legislature. Why not say there's a lot of charges that violence applies to. I mean, we could really break this out. Why not say, you know, start to talk about dim credits. Start to talk about the fact that a 5-year penalty gets you less than a year. Isn't that kind of the problem here? Because this penalty is just illegally carrying a gun beyond the scope of the law. We're not even talking about murder. We're not even talking about carjacking. And those sentences, even upon conviction, they barely serve any time. So is there not a broader problem that we kind of allude to with this bill, but really applies greatly beyond the scope of this bill?
Thank you, Delegate, for your question. This bill is dealing with what this bill deals with. Nothing greater, nothing lesser. You're free to put in a bill anytime you want to. Your first question you asked about can. And as you know, there's a difference between can and will. As the bill states, the judge can give you more time. The question is, will the judge give you more time? Maybe the judge won't give you more time because he doesn't want to ruin you. Furthermore, your question about the gun being discovered in the car, how was the gun discovered? And I can tell you this from experience. If you happen to have one of these guns that you own, and you happen to have a license, and your license is expired, and the law enforcement happen to see that you have this gun with you on your person, generally what will happen is they will confiscate your weapon until you go get your license straight. Then you can go and retrieve your weapon, but they will not give you back your ammunition, so that you know that.
I appreciate that. State's Attorney Bates, could you speak to that, please? My question about the reductions in sentencing generally, that applies here.
Well, it's a couple things. You know, I look at it from two different angles. Remember, I was a defense attorney for almost 20 years. So in terms of DIM credits and everything, Division of Correction, you'd be amazed. Sometimes I just think they do some of the things they want to do. You know, programs, that's a whole separate discussion what programs are in Division of Correction and things like that. But I do think that the purpose of this particular bill is the illegal handguns. And what I'm finding, what I'm seeing is that 3 years is not significant enough to talk about a harsh penalty. We could go on and on and on a lot longer to have a philosophical discussion about what the Division of Corrections is doing. But specifically this bill, one of the things I looked at with the law and understand my client should has to be a harsher penalty. There's one thing I also have. There's a jail card. I don't want to necessarily play it, but one of the individuals on the jail card talks about the reason they pled guilty to the 5 years was because he knows that specifically Ivan Bates, the new state's attorney, is not playing with these guns. And that is what they're talking about. I don't know what the data shows, but I know what they're doing.
Okay, I appreciate it. Thank you.
Thank you.
Vice Chair.
Thank you, Mr. Chair. I have hopefully two quick questions, and I think the first one might be for Mr. Bates, so thank you for coming out here. But I tried to ruin the punchline of this hearing by reading about some of the details in the press ahead of time, and some of what was discussed dealt with an age discrepancy, age disparity with regards to, you know, people getting one penalty if they were under 21 and another if they were over. And so I was expecting to see some language about that in the bill text, but this actually looks very straightforward, like a 3 to 5 penalty increase. Does this somehow implicate something about age discrepancies in penalties elsewhere in the code, or was that just a shelved concept?
Well, no, I think what it does, it makes the law, so you'll always have two ways you could charge individuals between 18 and 21. You can always charge them under the PS 133, if I'm not mistaken, which is 5 years, and then you'll be able to charge them under this 4-203. They're already receiving 5 years between 18 and 20, and now what you're saying is that the law, this law here that we have was codified, is the same thing as the other one. So I think it really does both by just correcting that one particular issue.
In other words, people who are over 21 right now would face less than 5 years. They would face only this 3 because they couldn't be charged with 5 under PS 133.
Yes, sir. They only receive 3 years. So that's also, it's just not fair. Between 18 and 20, looking at 5 years, but everybody else, 21 above, they're only getting 3. That's not fair.
Sorry, let me ask this. Do we need the other law then? If we move this one to 5, what's the purpose of the other law?
Oh, I agree if it's 5 years for everybody, but I don't make the laws.
Okay, sorry. And then the second, because we did this with how we define crime of violence. I hate finding these weird discrepancies in code and just letting them sit, so I just want to flag that. The second is, I note that this is a misdemeanor, colleagues. This is a misdemeanor. And so we had a prior discussion that means an offense like this does not come with later firearms ownership disqualification. Do I have that correct? This would?
Well,
and what about a future wear carry permit, like, say, 5 years down the road?
Well, it would, but one of the things that I talk about that I plan to do is that I do recognize in many ways for some of these young people could be a scarlet letter. However, you're usually going to be on probation 3 to 5 years. What I've said and that I will do is that, hey, A lot of these young individuals carrying these guns barely can read or write. Get your GED program, educational program, those wraparound services that we offer and that are offered, and no new arrests, no new convictions, not new arrests, no new convictions, and work on job training. I'll bring you back after 3 years. We're going to give you probation before judgment, allow you to expunge your record. So there is something if you work. But what I'm trying to do right now is, because the research shows individual carrying guns, 90% of the murders in Baltimore City are because of because of handguns. I just want to focus on that and stop that.
Sorry, Mr. Chair. This might be for Mr. Kroll. Are you able to just clarify what happens with someone's firearm rights in the future if they have a conviction of this type?
That would be a lengthy conversation that I'm happy to have with you offline. That would be a long conversation for this day.
Okay, thank you.
Little bit of it depends, I think, in that answer, but Delegate Phillips.
Mr. Chairman, thank you. And I with moving to the vice chair, I understand the term deference. Thank you. This is going to be to the state's attorney, and I will acknowledge my friend. I want to ask you this question in a way that helps people understand why this is so important and your perspective, having been a defense attorney. And so part of my question is, will this be a real deterrent from your perspective, having been on the other side?
You know, real quick, I was a prosecutor in Baltimore City State's Attorney's Office for 6 years. I was a criminal defense attorney in Baltimore City for 20 years. I've done cases all around the state. And one of the things I think I'm pretty much an expert on is understanding the psychology and mentality of individuals who are charged with crimes. Not everybody who does crime or charged with a crime is quote-unquote a criminal. People sometimes just make mistakes. But what I have learned is that when there are certain consequences, which everybody agrees is part of the equation, that's why when I gave you the data, we need to have more convictions on the state's attorney's end. We have to own that. But what I also understand is when you talk about penalties and harshness of penalties, individuals who are charged with crime, they understand everything. They understand the rules. They understand the dim credits. They understand what's going on that's their life. They're sitting there right now watching the news, because you go up in the pod in BCDC, they're going to be watching Fox News talking about what's going on, about the hearing and what's going on with guns. So when individuals know that there is a harsher penalty for carrying these illegal handguns, some will think twice. Not everybody, but some will think twice. So do I think that this will have an effect? It is one of the tools in the toolbox that will have some sort of an effect. Like I said, I already have one jail call. We're listening to 1,000 jail calls. And everybody's talking about, man, Bates ain't playing, Bates ain't playing, Bates ain't playing. Well, the reason I'm not playing is because I'm down here in Annapolis talking about I want a harsher penalty. But the judges, they don't always have to give it. We don't always have to ask for it. But it is there. It is there for them to know if you want to carry guns, and they're legal handguns, you now have the opportunity to be held accountable. It's not time served at home. You could potentially go to the Division of Correction. But you still come home. We still want to give you the wraparound services. And we still want you to change your life, expunge your record, and then get your license the proper way.
Thank you. Are there further questions for this panel? Seeing none, thank you all very much.
Thank you, Mr. Chairman. Thank you, Commissioner.
Includes those people testifying in favor. Again, the first panel now of those people testifying in opposition will include virtually people who are on the virtual, Mr. Amspaugh and Ms. Leno, I think are there, and then in person, Mr. Finnessy, Ms. Manuel, Ms. Robinson, Mr. Pennack. Are the others virtual? All right. Ms. Manuel. All right, what we'll do is there are two people who are testifying virtually in this first group. So what we're going to do is we'll take the people in person, go from my right to the left, to my right to my left, and then two people who are on virtually. So Mr. Pennack to begin, please.
Thank you, Mr. Chairman. My name is Mark Pennack. I'm the president of Maryland Show Issue. I'm an attorney, expert on Maryland gun law. So Maryland Show Issue is in opposition to this. because it punishes the unpermitted carry by an otherwise innocent person who has no record by up to 5 years. This imposes the same penalty, 5 years, that a disqualified person would have for carrying the same firearm. Indeed, it imposes a higher penalty for 5 years than a disqualified person would suffer if they were carrying a long gun. Under Section 5-207, the Public Safety Article, subsection D, the penalty for that is 3 years. That makes no sense whatsoever. Disqualified people who have already been convicted of a disqualifying crime should be treated more harshly than those who have simply made a mistake. And I'll give you an example. A person who carries outside limitations expressed in their permit is carrying illegally, even though they may have a permit. And I spent 33 years in the Department of Justice, and I can tell you I do not trust the prosecutor's discretion. He is your legal adversary. You don't rely on him to do justice. That's not his job. So the idea that don't worry about it, the prosecutor will take care of it, may be fine, but may well not be fine. I've known a lot of prosecutors in my life and in the Department of Justice, and they are great people, but their job is not to dispense justice. Their job is to enforce the law as the legislature writes it. I wanted to take one moment and ask this committee to address Lawrence versus State, where the highest court of this state found that the 4-203, which is what this bill would amend, is fatally flawed. And it's all in my written testimony. I would urge you to read that.
Please.
Hello, my name is Marisol Robinson. I'm a first-year law student at the University of Baltimore, and since 2019, I've personally been studying the effects that mass incarceration has had on crime and recidivism rates, specifically related to Black and African American communities, which will be most harshly affected by this bill. Mr. Bates said today that we need harsher penalties, and previously when discussing this bill, he has said that it's currently too easy for families to visit with their incarcerated family members with the lower penalty. I've seen both from my research and from personal experience that this is simply not true. There is a financial impact, but I also urge this committee to consider the arguably more significant social and emotional impact that these higher penalties have on families and the people incarcerated. When a child or teenager is forced to visit their family members who are behind bars, they're often exposed to the very harsh conditions where their family members are sometimes treated as animals by prison staff, which creates and increases trauma and fear of law enforcement. This increased trauma and fear of law enforcement is leading to higher rates of illegal handgun possession and other crimes because people feel that they can't depend on the local law enforcement to protect them. If the legislator has a goal of reducing the amount of gun-related violence and crime overall, approving this bill is not the way to go. Therefore, I urge the committee to issue an unfavorable report on House Bill 481.
My name is John Fennessy. I own Fortress Training, and we've been in business since the inception of the Firearms Safety Act of 2013, and I've trained over 20,000 Marylanders for the HQL or the Maryland Wear and Carry. What's changed in my business is who shows up. In 2013, it was all Caucasian males, either coming from overseas or they've have some experience in the military or they've somehow or another very high level of training. Last year, 36% female, 43% African American, Hispanic, or Asian are my client base. So I'm speaking to you of a very wide client base. And it's these people that have a carry permit, since we now have over 100,000 of them in the state of Maryland, which a delegate has said, it's probably greater than that, that inadvertently, accidentally, unknowingly walk into a situation to where all of a sudden they didn't realize, oh, I'm 500 feet across this line on a public school property. Oh, I happen to be in a Garrett Forest, and I want to do what I learned to do, which was offer law enforcement a courtesy. So you say, you're out in Garrett County, like, officer, I just want to let you know also, just as a courtesy to you, the state police has issued me this permit. He says, you have a gun on you? You're like, sure. 5 years now you're facing. for walking into BWI, one of your clients, 5 years. So I think there's a difference in intent, and I think that's critical. We said some important things. Intent, the lady that sat here, what's the intent of this legislation? All 24 state's attorneys agree. Not a single one of them put anything in writing to protect their citizens who are hardworking, honorable citizens that don't deserve to be treated like a hardcore criminal. And then we were just talking about the permit holder shouldn't never be a threat of paragraph 16. Reduce it, eliminate it, fine them, give them a minimum sentence the first time. There is a difference between a criminal and a hardworking, honest citizen, and you need to put that in writing. Thank you.
Good afternoon, Chair Clippinger, Vice Chair Moon, and members of the committee. For the record, my name is Yannette Emanuel, Public Policy Director with the ACLU of Maryland, here in opposition to HB 481. First, there's no evidence that indicates that there is a public safety benefit to increasing sentence lengths. Indeed, evidence shows that that more severe sentences do not deter crime more effectively than less harsh sentences. Second, there is a commonly accepted practice by law enforcement and prosecutors of focusing on minor or low-level offenses like illegal gun possession instead of the actual violent crime, which has time and time again proven to be ineffective in actually reducing violent crime, and we urge this committee to seriously question that practice. Comparing Baltimore City numbers from 2019 and the year with the most homicides over the past 30 years, and 2011, the year with the least murders during the same period, proves this. In 2019 in Baltimore City, there were 348 murders, 2,203 gun seizures, and 1,161 weapons possession arrests. In 2011, there were 196 murders, 2,178 gun seizures, and 1,224 weapons possession arrests. And third, part of the challenge has been, while there has been more willingness to criticize police publicly, they have still been primarily been able to operate how they historically have been and still continue to be shielded from accountability for the misconduct that they commit, which has a huge impact on the public's willingness to cooperate with police and actually apprehending those who perpetuate violence in our communities. And so for the foregoing reasons and the reasons you'll hear from my other colleagues, the ACLU of Maryland urges an unfavorable report on HB 481. Thank you.
All right, now we will go first to Mr. Omspaugh, then to Ms. Leno.
Thank you, everyone. My name is Brent Amsbaugh. I'm a Carroll County resident, U.S. Navy veteran, lifelong firearms owner. I have my Maryland designated collector license, my HQL, my concealed carry. I've jumped through every single hoop that Maryland expects me to jump through. And this bill does nothing to make me feel safe in the state of Maryland. There's no, one of the people that spoke previous to me said, put it in writing. I fully expect a carve out to be put in place for people who have their wear and carry, who aren't intending to run afoul of the law, if you can't remove the penalty completely, make it less than figure so I don't have to forfeit my gun rights. The state's attorney, I believe it was, said very nonchalantly, just go ahead and get your wear and carry permit. I don't think you fully understand the amount of time and money necessary right now to go ahead and do that. It's upwards of $750 to $1,000 to get from having nothing to having a firearm in your hand, the license to buy it, the license to carry it, and that's not even including the cost of the gun. You put everybody under your thumb, and this does nothing to help otherwise law-abiding Americans defend themselves outside of their home, and I have to worry more about what the state of Maryland is going to do to prosecute me than what the criminals are going to do to me out in town. For all those reasons, I think this requires an unfavorable vote. Thank you.
Ms. Leno, please, for 2 minutes.
Thank you. Good afternoon. Safety, stability, and access to opportunity. It's what can shift a young man's path from delinquency to democratically elected leader of this great state. Unfortunately, we know that access to opportunity historically has not been distributed equitably to all as a birthright. But laws can be shaped to prioritize increased access to opportunity over incarceration. The Johns Hopkins Center for Gun Violence Prevention and Policy advises pause when turning to an over-reliance on heavily punitive criminal legal systems to address violence. Black men are stopped by police, arrested, denied bail, convicted and wrongfully convicted, and issued long sentences at much higher rates than their white counterparts. As a result, nearly half of all Black men will be arrested before the age of 23. When they are released to their communities after these long sentences, they are not fixed, but rather further broken. This bill is promoted only on the hope, without any data that offers proof, that the impact of fear of increased penalties will, to quote Mr. Bates, who introduced this bill, hopefully prevent many homicides. In a recent article in the Baltimore Banner, he goes on to say that he wants people to get a taste of prisons, where they would be incarcerated further away from their family. I believe this is a dangerous ideology that promotes isolating and removing people from the community for longer periods of time for a misdemeanor offense in order to send the message against breaking the law. Keep the body locked away in order to take the mind. Break the will to resist. Maryland's history reminds us of the failures of this mentality. Our present-day reality awards us the shameful badge ranking amongst the leading states to incarcerate young Black males. Research and data tells us that the state already over-polices our Black and brown communities, and now it's being suggested that we return to over-incarcerate Black and brown communities as well. As a district public defender, I urge this body not to vote in favor of this legislation. Our best avenue as public servants is to pursue justice through the path that strengthens communities, increases access to opportunity without a return to tactics of mass incarceration. They do not work.
All right, questions for this panel. We'll go to Delegate Erican.
Thank you, Mr. Chair. This question is for Mr. Panak. So it sounds like you're not in agreement with the concept, but that you're concerned about permit holders being sort of looped in with this. So would you support sort of separating the two issues, making a separate code for violations where permit holders are making mistakes, where it's maybe a civil offense, fine or something like that, or where there's no intent, and then a separate one for people who are criminally carrying handguns who don't have permits and are willfully and knowing what they're doing?
So, speaking for MSI, certainly permit holders who have already been vetted and background investigated thoroughly, there's really no sense to throwing them in prison for years and years and years. And as they do under current law right now, it's just simply for carrying outside a restriction unknowingly. Because there's a strict liability offense, and the Supreme Court of Maryland has so held. So the fact that you did it by accident is irrelevant.
Right.
So there is a distinction in my mind as well between punishing people who are otherwise not disqualified and punishing the people who are carrying even though they're disqualified. And this bill makes no distinction between that whatsoever. The initial offense, simply who may be carrying because they haven't had a chance to get a permit yet or can't afford to get a permit, is inappropriate to punish 3 years, much less 5, because of that permitting violation.
Okay.
And really, it's just a permitting violation because on Maryland law right now, we are a shall issue state. The question is, how do you get the permit? And it takes months to do so and a lot of money to do so. So a lot of people are carrying in Baltimore now that are law-abiding people. And they ought not to be punished by 3 years, much less 5.
Okay, I understand. So your concern is really that people are being criminalized right from the outset. These people are not criminals. They don't have a record. They haven't ever committed a crime of violence, nothing. And because they just haven't been able to spend the $1,000 or so plus to get themselves to the point they would be eligible. So your concern is criminalizing those people in addition to the permit holders.
Yes, exactly right. Because, and I don't understand the state's attorney's office to say that those people ought to be criminalized. He simply say, well, we'll go easy on them.
Yeah.
Well, that's not going to cut it because eviction under this bill is a lifetime disqualifier.
Right.
So it's a lifetime disqualifier for 3 years.
Correct.
So
yeah.
they're out of their Second Amendment rights forever.
Right, because the rule is 2 years. If you are charged with a crime that can take carry up to a 2-year penalty, you're permanently disqualified from open
The line is convicted of anything which is punishable by more than 2 years. That's federal and state law.
Okay. Yeah, so this is already kind of draconian, in your opinion, on people who are otherwise law-abiding and not criminal.
Absolutely, particularly after Buren, where everybody has a right to a permit.
Right, okay. Thank you so much.
Delegate Cardin.
Thank you, Mr. Chair. Thank you all very much for being here. Either of the two gentlemen, I think, would be the appropriate people, but whomever wants to respond. So my understanding is you're opposed, Mr. Penick, you're opposed to 3 years. You're opposed to the code as it stands right now, the 3 years, right?
Correct.
Okay. And the reason you're opposed is because even if you're a law-abiding citizen who's carrying and you go to the wrong place, or you store it in the wrong place, or you make some sort of minor, some kind of minor infraction of some sort, you could actually violate this law, and you're saying there's no intent involved, so that you would automatically be able to be prosecuted for it.
That's correct. That's the current law.
Okay. And do you have any evidence or statistical notations as to whether people who are law-abiding, wear-carry permit holding people are being prosecuted on this?
Well, I don't have the numbers. I noticed from this fiscal note that there has been 300 and some odd convictions under this statute. That didn't break it down, but from the judiciary would have those numbers. But I will tell you that it is, this body enacted in 2013 a provision in 4-203, which this bill addresses, that actually makes it criminal to carry outside the scope of a limitation set forth in the permit. Every single permit issued by the state police has such a limitation, and that is you may not carry wherever the possession of a firearm is prohibited by law, which means if you stray over a property line onto, say, public school property accidentally, your permit is absolutely invalid, which means it might as well have no permit at all. That sets you up for a 3-year violation.
Okay. Is the judge allowed to provide to offer a PBJ on these kinds of charges?
Well, yes, and it depends on, of course, how it's prosecuted and what the judge is up mind to do. But I come from a prosecution background. I don't trust the discretion of the prosecutor or the court. I know what's in the law, and that's what matters to me.
Okay. So from the information I'm hearing, it's possible that 0 of these 300 charges could have been ones where people had a legitimate wear-carry. We don't know the numbers on that yet.
We don't know.
And it's possible that if there were any of them that were, it's possible that all of those could have been offered a PBJ in order to keep the record clean and to make sure they understand how important it is to stay within the confines of the law. It's possible.
Anything's possible, Delegate.
And the last question is it possible that somebody walks in, or this is to the gentleman, somebody can walk into the airport, I don't carry a gun, I make that clear, can walk into the airport forgetting that they're carrying a loaded weapon?
Sure.
Hundreds of times a year. Call Maryland Transportation Authority.
So the issue, so I don't understand how we can say that that's an honest mistake. You're walking into an airport with the one thing you need to know. How can that be an honest mistake?
In 2019, a Maryland Transportation Authority law enforcement officer walked onto a plane unknowing that he had a gun. Go call MDTA at the airport, and you will find out it happens. It could be in a bag. It can be in a carry-on, something you didn't know. It happens more than people are aware. The same way, including law enforcement violating this law. So it does happen.
And that is why, Mr. Chair, I think that the PBJ is an appropriate thing to have available for those mistakes. Thank you, Mr. Chair.
I have so much to say right now. I don't think we have enough time. Somebody in whose day job I'm very well aware of the people who forget guns. These sacrosanct things, and they go to the airport and they leave them in their bag, forgetting them in their bag. Great. Let's go to the next panel instead. So thank you all very much. We're going to hear from a mix of virtual and people in the room. So we'll list the people in the room first. Michael Burke, Nicole Hansen, Heather Warnken. Is Ms. Hansen here? I see Ms. Warnken. Okay, we're gonna have at least these two in the room. Virtually, we will hear from Mr. Carlin Weber, Mr. Beach, Mr. McKesson, Mr. Peabody. So we'll hear from those four, along with these two in the room. Go with you first, sir, in the room, then to Ms. Warnken, and then we'll go to the four people who are here virtually. So go right ahead.
My name is Michael Burke, out of Baltimore City. I'm a military veteran. I've got over 20 years in law enforcement at the federal, state, and county level. I've also served with the Department of Public Safety and Correctional Services. And this proposal is a mistake. I urge an unfavorable report. What the sponsor didn't mention is existing law calls for a mandatory minimum of 30 days for a first offense. So the first offender only gets 30 days and is released. Still is lifetime barred from possessing a firearm forever because the sentence in the original bill was a 3-year, raising this to a maximum of 5 years. Still, one possession of a firearm without a permit results in a lifetime bar. So Mr. Bates saying you can come back and get a license or permit later is ill-informed because one conviction, lifetime bar. In reviewing of thousands of background cases over the past, I've seen countless cases where these charges are filed in Baltimore City, Montgomery, PG, and other jurisdictions across the state. Routinely, they are simply dropped. They are not prosecuted. They are null prost. So even though the statute's been on the books for decades, it simply is routinely ignored by prosecutors and judges. However, one conviction, lifetime loss of a human civil right, forever. For an 18-year-old, for a 16-year-old, lifetime bar. Obtaining a handgun permit, for those who are familiar with the process, costs a minimum of $1,000. Going through the training, going through the background check, actually purchasing a firearm, a minimum of $1,000 cost. It's impossible for a resident of Baltimore City to obtain this permit because there are no ranges, there is no training available because the city disallows that process to happen. I invite questions if any of that is unclear.
Good afternoon. My name is Heather Warnken, and I am the Executive Director of the Center for Criminal Justice Reform at the University of Baltimore School of Law. Our center strongly opposes this bill, and it was my great honor to submit written testimony co-signed by 25 organizations and experts and counting, a broad coalition of public safety advocates, civil liberties organizations, law professors, and more. The evidence is simply not there to support this bill. And in fact, there is a large body of evidence demonstrating the ways it will undermine public safety. I want to be very clear. Addressing the immeasurable pain of gun violence and the growing number of illegal firearms in our communities must be of utmost priority. It is because I care so deeply about this crisis and the victims it impacts, not in spite of it, that I oppose this bill. Here are a few of the reasons why. Number one, this bill's supporters rely on a faulty set of assumptions about deterrence and have conflated certainty of consequences versus severity of consequences, two very different things. Studies demonstrate that longer sentences do not deter crime. Number two, this bill will undermine public safety. Notwithstanding the troubling talking points espoused by supporters of HB 481, incarceration takes a staggering toll on a person's life, weakens communities, and has criminogenic effects. The plan under this bill is to incarcerate people farther from home, notwithstanding the research demonstrating that disconnection from family is a direct contributor to recidivism. And number three, this bill is an ineffective use of our resources. We welcome the opportunity to engage with Mr. Bates and members of this body on alternate public safety solutions capable of producing a far greater return on investment discussed at length in our written testimony. Much like the disastrous war on drugs, we will not incarcerate our way out of this problem. We will continue to make it worse if we try. We must have the courage to give these evidence-based solutions a chance to work rather than regressing to politically expedient yet utterly failed strategies of the past. When we know better, we're supposed to do better. I welcome any questions. Thank you.
All right, we'll go to our virtual people now. They're not virtual people, they're just here virtually. Mr. Carlin Weber to begin for 2 minutes, please.
Good afternoon, members of the committee. Thank you, Mr. Chair. Thank you, Mr. Vice Chair. My name is Daniel Carlin Weber. I am a District 46 resident, proud of it, and I'm also a firearms instructor, and I'm here to urge an unfavorable report of HB 481. I echo many of the sentiments that have already been expressed before me. Maryland Criminal Law 4-203 is about 50 years old now. What led to the creation of that. And here we are making the same exact arguments that legislators and supporters long ago made, that guns are a problem in our society, they need to be curtailed, and only those permitted individuals should have any right to carry those in public. Now, I'm not arguing for completely unchecked restraints on the right to keep and bear arms, but what I caution is these items are extremely common in our society. There's over 420 million privately owned firearms in this country. Other cities are dealing with the fallout of what over-incarceration and over-policing of communities on guns looks like. Philadelphia, if you refer to my written testimony, the city of Philadelphia actually made a report on this very issue. And they recommend a lot of the alternatives that this legislative body and others are considering of other interventional techniques to deal with conflict resolution, to avoid incarceration, to avoid things blooming into bigger problems. Because of the distrust that has been caused by policing on this issue. This body is well aware of the Gun Trace Task Force and the fallout that we're still dealing with from the atrocities that deal with the war on guns, which is exactly what this is. And this is a fight that is over 50 years old now. And here we are today saying the same exact things that legislators of old did. We got to double down. This is completely incorrect. It hurts regular people, peaceable people who are just trying to protect themselves, whether they have a permit or even if they don't have a permit. As you heard, it's extremely difficult and expensive to get one. So for all those reasons, I urge an unfavorable report. Thank you very much.
Mr. Beach, please.
Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. My name is Michael Beach. I'm the District Public Defender for Montgomery County. Montgomery County population in the latest census was 20% African American. I ran the numbers myself last week. The jail population is 63% African American, up a percentage and a half from the summer. I'm the guy who assigns the serious cases in our office. I went through the last 5.5 months of cases I assigned to our lawyers of gun possession cases, where a gun was not used, brandished, threatened, implied, or anything. A discrete subsection of the cases I assigned, there were 37 of those cases. 32 of the defendants were black, 3 were Hispanic, and 2 were white. This bill has the risk, of course, of perpetuating the over-prosecution, over-policing, and over-incarceration of black and brown communities. Period. We should fix that first before we start making the laws that make it worse. I want to touch upon a couple other things quickly. I looked through as many cases as I could this morning. Criminal Law 4203 and Public Safety Article 5133 have, in every case I could see, been interpreted as separate statutory schemes that do not merge at sentencing. So by doing this increase, you're subjecting people over 21 to 5 years and people 18 to 21 to 10 years because those provisions will not merge as the courts have interpreted it. The other thing I think is important to add, the reality in my 19.5 years of experience as a public defender, on a 3-year sentence, even under the JRA, people serve way more than 8 months. The only way you only serve 8 months is if there's a ton of programs and you're able to get 10 days off a month plus 5 by signing up for every program that they have. They haven't had those programs during COVID and DOC. So our clients are not getting that kind of credit off their time under the JRA, and they're serving way more than 8 months on a 3-year sentence. So for all those reasons, I'm happy to answer any other questions and urge an unfavorable report on this bill.
Mr. McKesson, please.
Hello, committee. I'm Dre McKesson. I'm the executive director of Campaign Zero, an organization focused on ending mass incarceration and police violence. I'll support all of the other advocates who are against this bill. I'm strongly opposed to this bill, and I'll say 6 things. One is that this is not about alignment. If this was simply about alignment, we would make all the penalties 3 years. We wouldn't increase them to 5. So the talking point that this is simply about alignment is untrue. The second thing is that this committee has pushed all of us, all sides, the police, prosecutors, advocates, time and time again, to bring data where there are knowable facts. This is an issue where there are knowable facts. If people are not serving time when they're convicted, we can know that. The only data that the city state's attorney brought was the data that showed the historical failures of that office to convict people of these crimes. That is not a failure of the law. That is not a failure of most of the people in this room. That is simply a failure of that office. We don't need this bill to correct something that actually isn't a problem that is mitigated by this law. I'll also say I keep hearing this idea that this is just another tool in the toolbox. I'm reminded that not every tool is meant to be used in every situation. You don't build houses with forks, and this is one of those things where we continue to hear over and over again that we'll just throw it against the wall. In Baltimore, we have lived through every solution that was carceral. We lived it. And what happened? A lot of things happened, but the numbers didn't change. This is a moment where we should be pushing everybody to think more imaginatively about public safety. And if the data supported that more incarceration would actually make communities safer, I think a lot of us would make different decisions today. The fifth thing I'd say is that we should be wary of anybody who says that this law would have saved somebody's life, or the idea that it will save lives in the future. That's just not how public policy works, and those promises are just not true. And the last thing is that the idea that a singular jail call is enough to change statewide law is stunning to me.
All right. Chris Peabody now, please, for 2 minutes.
Good afternoon. This is Chris Peabody from Leonardtown in St. Mary's County. I urge an unfavorable ruling. The current law and this bill don't clearly make a distinction between legal gun owners and prohibited persons who use guns illegally. The supporters don't consistently make that distinction in their testimony between legal gun owners and prohibited persons using guns illegally. Maryland should amend the current law to only cover persons who are prohibited firearm possessors in accordance with federal law and leave the 99% of the rest of us out of it. By the way, there's 25 states today that have permitless carry for non-prohibited persons, with more coming this year. The issue is not just the penalty. The issue today is that too many prosecutors and too many judges do not use their existing tools. Please focus on a justice system that rehabilitates our offenders, vice just punishing them. Focus on reducing the repeat offenders. Police reports that are published in local media I read show a very high repeat offender rate that clearly means our system's not rehabilitating. I'm going to give you an example from Waldorf, just in February. February 5th, Waldorf. Police responded to a report of a domestic-related dispute. Preliminary investigation showed a man was inside a townhouse with his victim. They argued, and he produced a firearm and threatened to shoot the victim. Officers subsequently obtained an arrest warrant charging the man with first-degree assault, second-degree assault, and other charges. A bench warrant from Charles County Circuit Court was issued charging the man with violating his probation relating to previous charges, which include, in October 2019, he was arrested in connection with firing a gun towards a group of people. In November 19, he was charged. He ended up, my time's running, so he ended up getting 10 years, sentenced to 10 years, right, for illegal possession of a firearm. He was there for 14 months. That was back in 2019. In 2021, he ended up being caught with a firearm again. Right now, February 8th, he was released on his own recognizance with electronic monitoring. The system is not working. Thank you.
Nicole Hansen, are you here? All right, Ms. Hansen's not in the room. We'll take questions for this panel. Any questions for this panel? Delegate Williams?
It's more just a statement just for the gentleman, the first gentleman that spoke. It's Prince George's County. Just when you're referring, I would appreciate if you just stated Prince George's County instead of PG County. Thank you.
I apologize and thank you, ma'am.
Any further questions? Corrections on geography? Quite rightly. Anyone else? Thank you very much. That concludes the second panel. The third panel, Charles Watkins, Carla Mooney, Ashley Devon Johnson, Holland Brownlee. I believe all of them are virtual or should be virtual. I see Holly Brownlee, I see Ms. Devon Johnson, I see Ms. Mooney, and so we will hear from those three people and then go from there. So let's begin with Holly Brownlee, please.
Good afternoon, members of the committee. I am a felony trial attorney with the Office of the Public Defender, and I've been practicing law for 14 years. Criminal law Article 4203 applies where a gun, loaded or unloaded, is simply found in a vehicle. That's usually how I encounter it, or on the person, and the person either has no carry permit, is not law enforcement, or is not transporting the gun to or from an authorized location. This charge also applies where the handgun is simply being improperly transported, i.e. the gun's not in an enclosed container, the handgun and ammo are in the same bag, or the handgun is loaded. This means, for example, that with this charge, a person with no criminal record could be transporting their legally purchased firearm to a range, forget to take their ammo out of their range bag before they start driving, get stopped, and they will then be charged with and found guilty of this offense, and now they've lost their firearms rights. It may not surprise you to learn, therefore, that many defendants I represent are from other surrounding states where laws are much less complex and restrictive, and that many out-of-state permit holders already go out of their way to avoid driving through our state because of our draconian gun laws. I want to be clear that there are additional charges that already apply to scenarios where a gun is in use or has been used in another crime, and that there are also specific criminal charges that apply where the person in possession is a prohibited person. This law does not affect those charges, which carry penalties ranging up to 25 years in jail. Also, you're not going to see a repeat offender for this charge, because at this point they'll be a prohibited person and they're going to get other more serious gun charges, not this one. Understanding then that this charge applies to what is often just a simple mistake in what the law is by persons with no criminal record, I struggle to understand why the penalty needs to be raised. Yes, first-time offenders may get a PBJ, but then why are we raising the penalty? I am asking for an unfavorable vote on HB 481. Thank you.
Ms. Mooney, please, for 2 minutes.
Thank you very much. My name is Carla Mooney. I'm from St. Mary's County, Maryland. 29C is my district. I represent the DC Project in Maryland, and I also represent Armed Women of America. We have more than 5 chapters of women in the state that I represent. HB 481 is written as if it is to us concealed carry holders who have followed all of the rules, the regulations, and requirements. We've taken the 16 hours of classroom law overview. We've had our fingerprints, our background checks, and we are legal gun owners. The way it is written seems as though it's written towards us, but I do see and hear in those that have testified in the beginning that they're trying to reach out and stop the unlawful carriers of firearms, and they want to make their criminal sentences greater. I am for that portion of it, but it does not give anyone who's law-abiding any peace of mind, the way this is written, that it's not included for all of us as well. I do not agree with this, and I believe that you can find a way to go after criminals without going after law-abiding citizens as well. I feel like this is just vague. There's just not a direct line, and without it being in writing that you're not coming after us as law-abiding citizens. Look at SB 1. This law is set up to where it's not safe to carry our firearm legally anywhere. So all of a sudden, anywhere we go, we could be committing a crime because of this new regulation stating that any place that people gather is an illegal place to have a firearm. If someone wants to follow me, if you want to be a stalker and I need to go to the grocery store and I'm afraid to go to the grocery store, please don't do this and take away our ability to protect ourselves and call us the criminals. I ask for an unfavorable report on HB 0481.
Ms. Devon Johnson, please.
Oh, I didn't talk fast.
Good afternoon, Chair and members of this committee. My name is Ashley Devon Johnson. I'm the Policy and Research Coordinator for Out for Justice. I wanted to touch upon the fact that my husband is an armed security officer for the Secretary of State, and this bill was written too broadly, and it doesn't appropriately codify the illegal arms possessions that the sponsor wanted to kind of represent in this bill. However, I wanted to focus on Locking Up Our Own, which is a book by James Foreman Jr. This book examines the Black actors involved on the war on crime. It talks about Black prosecutors, Black judges, and Black legislators, and Black advocates. And the book asks the question, in the last 50 years, as America embarked on the process of incarcerating more and more people, what were the perspectives of Black America? We don't talk about this often. However, we have to address that many Black leaders and our Black elected officials were instrumental in igniting and fueling the war on crime. I really want to say that many communities were constrained without options available to them, such as funding for education, funding for housing, funding for rehabilitation, and could not get national gun control passed. So without options, our Black leaders made decisions to increase prison sentences and impose mandatory minimum sentencing. This system grew out of a system. We know that our criminal justice system grew out of a system of racism and a legacy that connects to slavery. However, this book found it to be true that both things happened. Our Black leaders were well-intentioned, as the delegate who sponsored this bill and the state's attorney who was behind this bill, very well-intentioned when they brought this legislation. However, we understand that our criminal justice system still has a very true historic tie to racism, and that expanding sentences like this is going to have a devastating impact on our community. We know that some of our former elected officials like President Bill Clinton have addressed this and have had to face what happens with crime every day. But I'm asking that we center the fact that criminal justice is essentially the civil rights fight of our era, and as we elect a new wave of officials in, we cannot go back and repeat the same mistakes of the past. And so I urge an unfavorable report on this legislation. Thank you.
Charlie Watkins was signed up. He has gotten on the call, so we're going to hear from him now for 2 minutes. But you have to unmute yourself first. There we go. Go ahead for 2 minutes.
Okay, thank you. As a Maryland State resident, I opposed Bill 481. As was previously mentioned several times, the current concealed carry permit holders have gone through training, background investigation, and this bill wouldn't be willingly violating the law, increasing the terms of imprisonment by 2 years for 3 years wouldn't further deter the already abiding permit holders. I think that the bill should be revisited and maybe amend the current laws to make the distinction on current holders and non-current concealed permit carry holders. Thank you.
Other questions for the panel? Seeing none, we thank you all very much, and that concludes the testimony on House Bill 481. We're going to go to 2 bills now from the Maryland Judiciary. We had to take them out of order because they had to go over and talk to people about money across the hall. It's, the choices we make, I suppose. But having said that, we'll start with House Bill 555, and we'll hear from Chief Judge Fader and Judge Jacobuski will come up and present House Bill 555. This basically asks for one more judge in Baltimore County, is that right? Oh, don't press the button. Don't press it. Don't press it. We'll get there. There we go. Welcome, Your Honor.
Thank you. One more judge and one magistrate for Baltimore County.
Oh, I don't know. All right. That's fine. Your Honor, go ahead.
Chair Clippinger, Vice Chair Moon, members of the committee, thank you very much for your attention to this matter. I'm going to just start briefly and then turn it over to Judge Jacobowski. The judiciary has for, I think, at least the last 5 years, had a process in order to determine the need for judgeships that involves a review of all of the different types of cases that come through and the numbers of cases that come through, and that's what we use. It's a model that was developed by the National Center for State Courts and that they have assisted the judiciary in implementing. And that produces a model of the number of judgeships that are needed across the state. And that's what we use to certify the need for judgeships to the General Assembly. This year, the review produced a certified need of 7 judgeships across the state, including 2 in the Circuit Court for Baltimore County. For a variety of reasons having to do with other constraints, including physical constraints in the courthouses, the judiciary has not sought any of the other judgeships. But due to the certified need in the Circuit Court for Baltimore County, as well as the fact that they have space, as you will hear now, and the ability to staff those the one judgeship and the one magistrate, the judiciary is requesting authorization for those additional positions. And with that, I will turn it over to the administrative judge for the Circuit Court for Baltimore County, Ruth Jacobowski.
Good afternoon, Mr. Chairman and members of the committee. My name is Ruth Jacobowski, and I am the administrative judge of the Third Circuit, which includes Baltimore County. I have served as administrative judge since December of 2020 and have been an active member of the Circuit Court bench for 21 years. I want to thank you for the opportunity to provide testimony today on behalf of the judiciary in support of House Bill 555. We currently have 20 judges on our court, and we are asking for just one additional judge and one family law magistrate. We have been deemed as the most critical need of judicial sources. I'm here to support that, and based on the fiscal year study that was done. I can also tell you in Baltimore County, our population has increased at least 5% over the last years, and our caseload has accordingly increased as well. Our need is critical and real. I can also report that I just had budget meetings with Baltimore County's budget team, including Stacy Rogers. They are fully recommending to the County Council that we be approved for an additional judicial assistant to support a judge. And we also have the funds available to support a magistrate assistant. We also have the space in our county courts building to support and house both a chambers for another judge as well as a magistrate and their assistants. I'm happy to answer any questions, and I thank you for your support.
Are there any questions for this panel? Requests for postponements of any cases? Delegate Cardin, right out of the gate, Delegate Cardin.
Thank you. Yes, I
Better be a softball, Mr. Cardin.
I'm in front of Judge Jacobowski quite a bit, Your Honor.
I've known Mr. Cardin for quite a while.
Yes. Your Honor, it's always a pleasure to see Your Honors here.
As it is for me as well.
I just wanted to confirm, that, and you said it already, but you have made sure that the county is willing to put up the money for all the ancillary requirements like assistance and supplies and everything else. Is that correct?
All of the above. I have.
And the court actually pays for the magistrate's assistant as well.
That's correct.
And the court is, the judiciary already has that in its budget that's going to be before the governor, and we're going to get that passed as well, right?
Right. We have the money.
Okay.
And we have the support of the county, its executive's office, and it's going to go to the council, and they're going to recommend it.
Great. And the last question is, would it surprise you to know that the census of 2010 showed that Baltimore County had the largest influx of seniors and children of any county in the country except for Dade County and Broward County, Florida? Would that surprise you?
That would actually not surprise me.
And then in 2020, although we haven't digested all the information, it seems as if our senior population, which this magistrate will actually be helping with in many issues, is also increasing at a larger percentage than the rest of the state.
That doesn't surprise me at all. And looking at the guardianship cases, our guardianship cases have increased. We have separate judges that just handle guardianship. Our family law cases have increased. So that doesn't surprise me at all, which is why we need an extra judge and an extra magistrate.
Thank you.
Thank you, Mr. Cardin.
Anyone else? This is softball.
Yeah,
Absolute softball. All right. Sure to get this next postponement request now. All right. Seeing no further questions, we thank you both very much.
Thank you.
And
Thank
that
you so much.
concludes the testimony for House Bill 555. But we're not done yet with the Chief
Okay,
Judge.
I'm going to step back for this one.
That's fine. All right. We're going to hear from the Chief Judge. I'm sorry. Well, yeah. Okay. The Chief Judge, again, for House Bill 536, along with Chief Judge Morrissey, Chief Judge Wells, and there are two people virtually. Judge Carrion.
Judge Carrion is right here at the table with us.
Hi. Oh, I'm sorry. That's fine. And is Ms. Katana here from the Bar Association? She is on virtually. All right, we'll put her up. That's fine, and we'll go ahead for. We will grant the Chief Judge 3 minutes. Just saying, and then everybody else gets 2. Go ahead. Sorry, Judge Morris.
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. I am pleased to be here to testify in support of House Bill 536. I want to thank the chair for introducing the bill and the committee for considering it. I will note that the original bill was not the one that was filed. We've received a copy of amendments, and I assume that everybody on the committee has the amended bill, which is the one that the Judiciary had proposed. The purpose of the bill is to provide some protection for judicial officers whose roles necessarily place them at risk of personal attack from disgruntled litigants by providing a mechanism to keep their home addresses and any previously unpublished personal telephone numbers from being available on the internet. Others on the panel will give you some more of the specifics of the potential harms and threats that have been received, but I will note that it did make big news when protests occurred at the home addresses of some members of the Supreme Court last year. If those addresses can be found and protests organized, think of the ease of finding the home address or telephone number of the judge who took away custody or who sentenced an individual's child or fiancé to prison, or many other circumstances that give rise to threats to members of the judiciary. In an instance that I think might be lesser known, one of our state appellate judges received a letter from the Capitol Gazette shooter on the day of the shooting indicating that that judge was also a target of the individual's ire and may have been next in line. That judge had been on a panel, an appellate panel that had handled a case involving that individual previously. The individuals who are protected by House Bill 536 are Maryland judicial officers, federal judicial officers, parents, spouses, and children of those individuals. And we also received a request to add the governor and lieutenant governor to the bill, and the judiciary is certainly supportive of adding them as protected individuals on the bill. The bill is very narrow and modest in what it protects: home addresses and previously unpublished phone numbers. The basic requirement of the bill is that if a protected individual requests removal of that information and the entity posting it is able to verify that the individual is who they claim to be, that the information has to be removed within 7 days. Remedies for a violation include declaratory relief, an injunction, and attorney's fees. And if the entity that violates the statute is a private entity, remedies also include damages and, if willful, punitive damages. I note that one category of records that is not protected is land records. That is because there are special difficulties involved with land records. So in an uncodified provision of the bill, it would create a work group to study how to extend that protection or similar protections to that. I thank you for your consideration, and it will be available for questions, but now turn it over to Chief Judge Gregory Wells of the Appellate Court of Maryland.
Mr. Chairman, members of the committee, thank you very much. My name is Gregory Wells, and I am the Chief Judge of the Appellate Court of Maryland. And I'm here to ask for a favorable report on House Bill 536. We recently had active shooter training at my court, and sadly the need for such training is a reflection of the world we live in today. And as much as I admire and trust the security officials who protect the courthouse, they can do little to protect me when I'm out in public or at home. Last year, I authored an opinion affirming the conviction of a man for stalking and harassing a Montgomery County prosecutor. Some of the evidence against him was that he had repeatedly gone to the victim's house, obtained information about her Wi-Fi network, wrote lewd and threatening emails to her containing personal information about her family, among other things. After the opinion came out affirming his conviction, the defendant began writing threatening letters to me and to other members of the panel. We alerted security, and for a while we were all on a heightened state of vigilance. The man was later picked up for violating his probation, and I strongly suspect that if he was able to obtain my home address or phone number, his harassing behavior would have escalated. What happened to me was alarming, but no one would want what happened to Judge Esther Salas and her family. Roy Hollander was a litigant in a case before Judge Salas, who serves on the District Court in New Jersey. On July 19, 2020, Hollander went to her home, shot and killed her 20-year-old son, Daniel, and wounded her husband. Unfortunately, what happened to Judge Salas's family is part of a nationwide trend. U.S. Marshals report that federal judges are the target of 4,500 threats or inappropriate communications last year. We ask, as members of the judiciary, that you all favorably consider House Bill 536, which is not a complete answer, but is a step in the right direction to preventing events such as I've described. Thank you very much, Mr. Chairman.
Good afternoon, Mr. Chair. Good afternoon, Mr. Chair, Mr. Vice Chair, and members of the Judiciary Committee. My name is Audrey Carey, and I am the Administrative Judge of the Circuit Court in Baltimore City. The safety of judges and their families is essential to both the individuals involved and to the democratic and fair administration of justice throughout the judiciary. The judiciary is specifically designed as the branch of government that requires protection to be free from intimidation and harassment so that its judges may render fair and impartial decisions. It has always been a threat to the safety of court officials, but in recent years, due to the easier access of public information, the number and intensity of threats to judges has increased. You have already heard about current national trends. The reason why this bill is important and why personal information of court officials must be protected is to help in preventing these acts from occurring. The nature of a judge's work, and in my personal experience, the work as a Baltimore City Circuit Court, affects the lives of people before us in many ways. We determine or preside over the determinations of who wins and who loses. The Circuit Court for Baltimore City is the largest Maryland Circuit Court with 35 sitting judges. Our dockets are divided into 4 divisions, including criminal, civil, family, and juvenile. Judges sitting in those dockets have a wide range of cases, case types that have profound impacts on parties: criminal sentencing, separation of individuals from their children, divorces, contract disputes, evictions, and other cases that lead people to act with malice and emotional times. Okay. In Baltimore, thank you, Mr. Chair. In Baltimore City, our judges have faced the following challenges so that you get an idea of what we're talking about. Threats involving surveillance and targeting of validated gang groups, suspicious packaging and threatening letters to judges' personal residences or chambers, stalking at personal residences, verbal threats at public meetings and through telephone calls, and protesting outside a judge's residence during a high-profile criminal trial. This is all in addition to the potential threats judges face with the aged courthouses from individuals attempting to bring in weapons and delivering suspicious packages into our courthouses, including an incident in which a defendant threw a pitcher of water at one of our judges during a sentencing, injuring the judge. For all of these reasons, we thank you for your time and favorable consideration of this bill.
Judge Morrissey, please.
Good afternoon, Mr. Chairman, Mr. Vice Chair, members of the committee. My name is John Morrissey, and I'm the Chief Judge of the District Court. As a lot of you may know, the District Court is a high-volume type of court, and you can see I handed out a PowerPoint where we see millions of people every year. In this past year, in 2022, unfortunately, our district court security assisted with local law enforcement on 7 credible threats to district court judges. And you can see from the first page of the slide the number of counterband that's attempted to be brought in. The next 2 pages show things like swords in a cane, knives that look like brass knuckles, a taser pen, knives in a comb, knives in a belt buckle, and oddly enough, on the 3rd page, a gun that points out to be a knife. I don't know why someone would do that. The 4th page has just an assembly of what those weapons would be. Most disturbingly, I got a call on November 20th in the early morning hours, probably about 2 o'clock in the morning, that an individual had, from about 40 yards outside the Essex Courthouse, fired a high-powered AK-47 rifle into the front of that building. And you would think, fortunately, it was at night, but there was a security guard there as well as 2 of my commissioners. Fortunately, they were on the other side of the building. But you can see from the photo that The bullets penetrated 2 sets of protective doors and then into the lobby, and it actually went all the way through into where the clerks would be sitting. Had that occurred during regular business hours, there would have been multiple casualties as a result of that. And then, unfortunately, again, in Baltimore County, in our brand new, beautiful Catonsville courthouse, again, in the wee hours of the morning on April 5th of this past year, an individual, as you can see from the picture, had a lighted Molotov cocktail that he threw at the commissioner's entrance, and there were commissioners inside at that time. These threats are very real, and we believe this would help us, and I appreciate a favorable return and thank the committee for listening to us.
Ms. Katana, please.
Thank you. Good afternoon, Chair Klippinger, Vice Chair Moon, and members of the committee. My name is Shally Katana, and I serve as Advocacy Director of the Maryland State Bar, where we represent more attorneys and judges than any other organization in the state. And as you've heard, I would echo everything that you've heard from the judiciary, and I'd add that ensuring judicial security is critical to the MSBA and to the entire legal profession. And the practicality of this bill and its approach is limited on focusing on home addresses and unpublished telephone numbers, and it also provides a very reasonable process for judges who qualify to request that sensitive information be taken down. This bill is also important for the future of the legal profession, as more and more attorneys decline to seek judgeships for a variety of reasons, one of which is this concern about security. And so future retention and recruitment is really important. And for those reasons, we ask for a favorable report for this bill. Thank you.
Questions now for the panel. We'll start with Delegate Tolles, then Eric Han, then Bartlett. Delegate Tolles.
Thank you, Mr. Chair. I was looking at this. I think my question is answered, but it does cover prosecutors. It looks like it covers prosecutors as well, or just judges. And does it cover everybody in the courthouse?
There were differences in the
federal
in the bill and the amended bill. The amended bill is what the judiciary had originally asked to be introduced. It defines protected individuals, and the individuals who are covered are state judicial officials, federal judicial officers, and parent, spouse, or children of them. And again, the judiciary, on request of the governor's office, would support an amendment to include the governor and lieutenant governor as well. But those are the categories that are covered by the bill that is currently amended.
Not the legislative branch?
The judiciary does not take a position with respect to that. That's not really our. This is because of the threats to judicial officers, and that's what we've covered. We certainly don't take a position one way or the other with respect to others who may have an interest in similar protection.
Well, I would on a serious note, I thank you for your testimony, and I can appreciate and, sympathize with, attempting to, keep the courthouse safe and the judges safe. I'm just wondering, what about the rest of the staff in the courthouse? I can share with you 2 stories. One, as a former council member in Prince George's County, prior to me being elected to the council, there was someone who came into the council and attempted to go after one of the council members, so much so that it prompted security and to change, reconfigure the entire offices for all the council members because of this, that individual's safety and the ease for them, the perpetrator, to be able to come in. Second story, I was in a courthouse actually. I think it was my last semester of law school. I just finished. I was assisting a prosecutor, and the person knew me from being on the council and didn't maybe was a little, forthcoming with things I didn't like, particularly, crime and things of that nature. And they went after the prosecutor and said, "I know you too. We're not, you are in it too." And it was, a group of unfortunate, look, I'm just authentic, I'm going to say it. It was some folks on Black Lives Matter that were attempting to go after the prosecutor and got me. And unfortunately, a deputy sheriff had to walk us to the elevator and get on the elevator. So there is concern, for the prosecutors as well. So I really hope because they're in, obviously the ones doing, a lot of the heavy work and having to deal with that. So I don't know what your take, you already answered it, but I definitely would consider you being open to a friendly amendment to at least the prosecutors and other courthouse staff.
I appreciate that judicial officers are certainly by no means the only people who face threats. Judicial officers face very serious threats. All of the people who are covered by this are people who are in categories that receive threats on a fairly regular basis. The judiciary's legislative activity is necessarily narrow by virtue of our role. We have limited this to particular individuals within the judiciary. It's not intended to take a position on whether anybody outside of the judiciary should or shouldn't be included. Certainly, the judiciary has no opposition. But the bill that was forwarded was a bill that was limited to the judicial officers in view of really our role within the governmental system and a view of an appropriate role for the judiciary with respect to the legislative process.
Right, but the prosecutor, so you would not take a position if a friendly amendment was offered for at least the ASAs or even, I don't think it covers the state's attorneys.
I don't think it covers anybody outside of the judiciary, and no, we don't have a position on anybody outside of the judiciary with respect to these protections.
Thank you, Your Honor. Thank you, Mr. Chairman.
Thank you. Delegate Erican and Delegate Bartlett.
Thank you, Mr. Chair. Thanks for bringing such a dream team together here today. We feel really special. Like Delegate Tolles, and the chair knows this, I also got death threats I hadn't even made any enemies yet, and people already hated me and wanted me to die. So it does happen. We are in assumed risk positions. And we've seen Jersey, there's just 2 council people that were murdered in the last week or so. The chair had mentioned to me that in the Southwest U.S., there was several delegates whose homes were attacked in the last, couple of weeks or whatever. So it is a problem, certainly, and perhaps an escalating problem. I'd have to look at data to see. But I do sort of wonder, are we creating a special class? Like if we start adding the judiciary and of course, like she mentioned, the staff of the judiciary, because they are in the same essential positions while they're at work, especially, the legislature. The governor wants to be added. He's aware, I'm sure, that he lives in the governor's mansion. There's really no way to blind people to where he lives. So I'm just wondering if you have any thoughts on this creation of essentially like a special class of people that gets to enjoy these benefits of hiding themselves from society.
I guess I would take some issue with the last thought of hiding themselves from society. This does not affect anything that happens in the courthouses. There's a great need for security in the courthouses. Right. There's some additional work that's being done in response to the threat, more than a threat, from the shooting up of the Essex courthouse. And that is, I think, where the most serious threats are. But this is an effort to address threats that exist outside the courthouse. And I don't think it's as much of a special class as this is a group of people that faces real, present, constant, consistent threats from individuals who are often facing challenges involving mental illness and who have liberty interests that are affected by the proceedings and have child custody and family interests that are affected by the proceedings, and where there are documented consistent and increasing threats, including what we all saw with the family of the judge in New Jersey, with a justice of the Supreme Court that had somebody with a semi-automatic rifle going to his home last year. So I think that it's a need. And again, we don't take a position with respect to anybody else, but this group of people is at risk, receives real, actual threats, and that's why we've proposed this.
Yeah, my final suggestion would just be for your work group. Secretary of State has a program that blinds the home addresses, even in the online real property system for victims of domestic violence, so maybe the system could be duplicated.
Thank you.
Thank you, Mr. Chair, and thank you, Your Honors, for being here. I have two questions. Hopefully they'll be quick. First question actually is for Judge Morrissey. You do have a PowerPoint, and let me say it is powerful. If you can you opine as to whether or not having more virtual hearings, as I noticed the numbers went down during the pandemic, and I know there were less, trials and things like that, but having more virtual proceedings, I should say, would help, in your opinion, with some of the issue that you saw here, or do you not want to opine on that? And if you don't, it's fine.
Well, I can tell you, Delegate, you probably know this firsthand, we still are having virtual hearings in all of our courthouses. The extent, we were forced into doing it mostly virtual when the pandemic kind of first came, and then as it resurrected a couple times over the years. And I think we found, we're still kind of getting there, but I think we found a balance between what works and what doesn't work virtually. Some things it's very good for, like scheduling conferences and things like that. Right. Full-blown trials, it's not so good for. I think it would cut down on the volume that comes to the court, but there's also something, we have to be open and we have to be accessible to the public, and I think we're just going to see this. Unfortunately, I have a very dedicated group of bailiffs that really take care of us on the district court level, and we've embarked as a result of that. That Essex thing scared me. I mean, literally scared me. We were down there the next morning, and the commissioners that were at the other side of the building didn't know which way to run because they heard the gunshots and couldn't figure out where they were coming from. And so we've embarked on in our last two budgets, we've requested additional funding to harden our courthouses. And so we're trying to do that from a physical level, starting with the kind of courthouses that are the most at risk. I don't know if that answered your question.
It answers my question. And you touched on what I needed to know. My second question is actually in reviewing the bill as it was originally written and the amendment. So in the original version, there was 3 days to take down the material if there was a request made. In the amendment, I see that it's 7 days. In the world of the internet age, this seems like an eternity to me. So I just was kind of wondering if we could maybe even, if what the reasoning was behind such a long time span. Is there a whole lot of mechanisms that have to go into place in order to take it down? Or was there something else involved? So like, I'm thinking hours. I'm thinking immediately. I'm thinking promptly, words like that. So does anyone have any, anything that you can enlighten me on that?
Do you know?
I would think other than we just felt it would be a reasonable period of time to get the letter to the appropriate people at these organizations and make the decision to take it down. They need to confirm that we're who we say we are, and then not exactly sure how they would go about the process of removing it. It may take some time.
Yeah, I don't know about the specifics of that change from 3 to 7, but I was also going to point out that one thing that is in the bill is, of course, they need to be able to identify that the person making the request is who they say they are. That could take some measure of time depending on where they are. But we can figure out if there was a specific reason from 3 to 7 that caused that to happen, but I don't know.
Do you all utilize the benefit of MD Think at all? Or, the court process, you all use OIS, the general state. I guess every county uses its own cybersecurity mechanisms. Meaning what I'm getting at is we are trying to centralize more of the state cybersecurity for this very reason, so that you don't have to prove who you are. We already know who you are. And then we can, if we need to take something down, we can take it down quickly. Now, we can't control the entire internet yet, but, but I understand that. So I was wondering if you all work at all with MD Think or with the state, you have the support of the state OIS or anything of that sort? And if you don't, that's fine. That's a whole nother conversation. I was just wondering.
Chair, we call our IT department JIS, Judicial Information Systems, and they work very closely with DoIT and the information security functions there. In fact, they're on at least one board together, and just recently I've been invited to sit on another one that involves technology security, and we're very dedicated to that and very aware of it, and we appreciate the support from DoIT and intend to keep working with them to have best practices implemented.
Okay, great. Thank you.
Chairman, may I just give a parting appreciation to the panel? As a member of this committee, it's a great honor to have such esteemed panelists in front of us sharing your information, your concerns. And I believe that your job as jurors is the toughest, both intellectually and emotionally, of all the civil service occupations that we have. And it is very humbling to have you before us pleading your case. Thank you very much.
Thank you.
What's that?
Isn't that so?
Isn't that so?
All right. He doesn't even need a postponement or anything. All right. Any further questions? Seeing none. Thank you all very much. Thank you, all of your
Thank you all.
for being
Mr.
here.
Chair, we did support a bill this session.
I noted it. I noted it.
It's my first
They
one.
got to bring the defibrillator out for me a little later. It was amazing. It was kind of
I'm
remarkable.
100% right now because this is the first bill for me. Thank you all, committee
All
members.
right.
I appreciate it.
Okay, last bill. Many people, and we're going to get started now with House Bill 307, Delegate Bartlett. We'll hear from Delegate Bartlett for 3 minutes. Peter Benjamin, Cheryl Bost, Karen Herron, Katie Day, Dr. Joseph Saccharin from Johns Hopkins. Is he still here? Can we manage to pull that off? Dr. Saccharin? Don't see Dr. Saccharin.
How are you doing?
I'm doing good.
Okay, she's good.
Is Dr. Saccharin here? All right, that's fine.
Oh, you're fine. You're fine. No, did he call your name? Come on up. You're fine. You're fine.
Dr. Saccharin, go on up. Do we need a fifth chair? The people I have on the first panel, just to be sure, the people I have on the first panel listed here, Delegate Bartlett, Peter Benjamin, Cheryl Bost, Karen Herron, Katie Day, and Dr. Saccharin are the people I have on the first panel. If you want to mix and match, that's fine. I'm happy to switch somebody out. I just need to know who I'm switching for so that I'm...
Melissa Wiley.
Okay, so Melissa Wiley, for who's she switching with?
I can go to the second.
You want to go to the second panel? All right, so for Ms. Bose. All right. So we'll put her on two. Just trying to make sure we don't miss too many people. Okay. Delegate Bartlett, please, for 3 minutes.
Thank you, Mr. Chair. And my name is Sandy Bartlett, representing District 32, Anne Arundel County. I'm only going to talk about one family's tragedy, although I'm sure you know there are many. We wake up most mornings to news about a shooting victim or multiple victims. We hear about children bringing firearms to school. You already know that gun violence is currently the leading cause of death for adolescents in America. So I'm only going to tell you about one family and how we can help the children in that family. At one point, motor vehicle crashes were the leading cause of death in the first decades of American lives. In 2009 alone, vehicle crashes killed over 33,000 people and injured another 2.2 million. More than half of the people killed in car crashes were not restrained at the time of the crash. We learned that wearing a seatbelt is what became the most effective way to prevent death and serious injury in a crash. We went from 11% seatbelt use in 1985 to nearly 85% use in 2010. We saved hundreds of thousands of lives, per the statistics posted in a 2009 article in the American Journal of Public Health. What we learned from deaths from polio, smoking, car crashes, and are now learning about gun violence is that a comprehensive public health approach can lead to reduced instances of death. We can learn from public health successes like car safety. We can apply these lessons to preventing gun violence. By using a comprehensive public health approach to car crashes, the U.S. reduced per mile driving deaths by nearly 80% from 1967 to 2017 per the National Traffic Highway Safety Administration. Every year, on average, almost 8,000 children and teens from the ages of 1 through 17 are shot. Based on a 5-year average from the Violence Policy Center from 2014 to 2018, every year on average, 8,000 children ages 1 through 17 are shot. Every day, 22 children and teens in that same age range are shot. I imagine a world where we do not wake up to headlines of another shooting, mass or otherwise. It's a big task. Gun violence seems to be taking over our lives. Gun violence has become the new normal, unacceptable. We must do more. As you heard today, we had a bill on with respect to guns. Mr. Chair has a gun storage bill with elements that will save lives as well. If passed, House Bill 307 will require a safer storage of firearms. Second Amendment. Now, really quickly, because I'm running out of time, let me talk about the family. On March 20, 2018, a 17-year-old student gained access to his father's gun, entered Great Mills High School in St. Mary's County, and shot 16-year-old Jalen Wiley in the head and injured a 14-year-old boy. Jalen died from her injuries. I'm out of time. Her mother is here, and she will tell her story.
Good afternoon, and thank you for the opportunity to speak today. I am here on House Bill 0307, Jalen's Law. March 20th, 2018 was a normal day for my 16-year-old Jalen. She would have been 21 on the 24th of this month. She got up that day, she had breakfast with me. The girls bickered back and forth about pants and socks, who was going to wear what. She got picked up by her friend Jessie and went to school. What is not normal is another young person, 17, the shooter, decided they were going to bring a gun to the school in his sweatshirt pocket. He had access to a gun owned by his father because of a few small loopholes in the existing law. He walked up behind her and shot her in the head. The aftermath of losing a child is devastating. Losing one to a totally preventable is beyond what can be described, but I will try. I have kids that don't feel safe going to school. I have kids that have mental health issues, depression, anxiety, just to name a few. I have a child with PTSD and ODD, oppositional defiance disorder, brought on by PTSD from losing her sister. I have an 8-year-old that sleeps with a keychain with Jalen's picture because he misses her so much. I have a 6-year-old that cannot understand why anyone would bring a gun to school, let alone hurt his sister. And I have a 3-year-old who has never met her sister, who asks almost daily where heaven is, and when we bring flowers to the cemetery like we did yesterday, she calls her plaque Jalen, honey, and kisses her because that's what she knows. This is just my kids. As a mom who panics every time my children leave to go to school, when we're at a fair, there's tons of people. You have a mom that can't stand the sound of balloons popping because even though I wasn't at the school when Jalen was shot, that's all I can think of. You have a mom who asks friends' parents if they have guns in their home and are they properly locked up and out of reach of my kids and theirs. I've said many times, if you have guns, fine, just do it safely. If there are a few extra steps to take to do them, if it means you have to supervise a 17-year-old with a handgun even though they have taken a hunting course, do it. I'm asking for a favorable vote on Jalen's Law. If it helps to keep even one child alive and safe, it's worth it. Children should not be dying because of irresponsible adults that have no consequences for their unsafe actions by not locking up their guns or having access. Thank you.
Yeah. Thank you, Chair Clippinger, Vice Chair Moon, and distinguished members of the Maryland House Judiciary Committee. Thank you for the opportunity to testify in support of HB 307, also known as Jalen's Law. And I'm so sorry about the loss of your daughter.
Thank you.
My name is Joseph Saccharin, and I come before you today not just as a Brady board member, but as a survivor of gun violence, where at the age of 17, I went from being a healthy high school student to collateral damage after nearly being killed when I was shot in the throat with a .38 caliber bullet. That moment changed the trajectory of my life and inspired me to go into medicine and become a trauma surgeon, where I currently spend most of my time dealing with the daily toll of gun violence at the Johns Hopkins Hospital. The views expressed do not necessarily reflect those of Johns Hopkins Medicine. And while I'm grateful to be here with all of you discussing the most important public health crisis of our time, I'm also incredibly heartbroken and disappointed at having to watch the daily carnage destroying families and decimating communities across this state and beyond. My personal experience as a survivor and a trauma surgeon has allowed me to see firsthand that the best medical treatment is prevention. Nationwide, nearly 4.6 million minors live in homes with unsecured firearms. And when you think about the complexity of the public health problem we face, when you look at unintentional shootings, school shootings, and suicides by minors, we know that 70 to 90% of those firearms are acquired from home or from homes of friends or relatives. As a trauma surgeon, we come face to face with the horrific reality of gun violence every day. We operate on children who are barely clinging onto life because the gun's not safely stored. We've had to deliver babies from dead mothers who were gunned down while sitting in their own car. And we care for high school students bleeding to death with pulverized bone and mangled extremities. We need to do something. In America and in Maryland, gun violence is the #1 cause of death in children. It's not car crashes, it's not poisonings, it's not cancer. So the bill before you today, HB 307, will encourage responsible and safe firearm storage practices and save lives, updating Maryland's existing child access prevention laws to be more inclusive and ensure that fewer minors can and do access firearms. For these reasons, I strongly urge a favorable report on HB 307. Thank you.
Thank you. If you'd move the microphone to your right, please. Thank you. Go ahead.
Good afternoon. Karen Herron, Executive Director of Marylanders to Prevent Gun Violence. I'm here today in support of HB 307, Storage Requirements and Youth Suicide Prevention, or Jalen's Law. You are being reminded today of the heartbreakingly tragic story of what happened to Jalen Willie. You have also heard how the ripples of that tragedy have and will continue indefinitely throughout that family and community for the rest of their lives. And this scenario restarts daily in this country and compounds traumas over and over again. You will also hear today from the Reverend Greta Willis, who is going to tell you about how a recent Baltimore case is impacting 2 families and that community, all of whom are reeling from an unbearable loss. And all of these incidents are entirely preventable. I actually do think that most gun owners want to behave safely. They truly believe that firearms make them safer, and yet the messaging around firearm ownership and safe practices is anything but clear. While many gun owners are absolutely exercising best practices in how they store their firearms, many still don't. Perhaps those gun owners do not know or do not believe the plentiful research out there that tells us that 4.6 million kids live in homes with loaded, unlocked guns, or that between 2009 and 2018, gun suicides of minors increased by 82%. In those cases of youth suicide, nearly 80% of the time, the owner of the firearm the youth used was either the parent or another relative. Firearms are the #1 cause of death for America's youth, largely because of how easy it is to access them in this country. We start fixing this by making sure that we have clear guidance in place that responsible gun ownership starts with storing firearms unloaded and secure. MPGB urges a favorable report.
Also on the first panel, we have testifying virtually Katie Day. Katie Day, please, if you would testify now for 2 minutes.
Great. Good afternoon, Mr. Chair and members of the committee. My name is Reverend Katie Day, and I live in Cambridge, Maryland. I would like to speak in support of HB 307, Jalen's Law. My husband and I retired to the Eastern Shore from Philadelphia. As you know, Philadelphia has a very high rate of gun violence, and I was involved in faith-based efforts there to advocate for stronger gun laws. We were looking forward to being in a state with lower levels of gun violence as a result of common sense gun laws. However, we have seen the numbers of shootings and gun deaths rise in Maryland, and most tragically of children injured or killed by guns. Even in our small city of Cambridge, gun deaths spiked last year from 1 or 2 a year to 6 in 2022, including a 5-year-old child. Jalen's Law is a small but important step in protecting our kids. The Eastern Shore is hunting country, and I know that overwhelmingly most hunters secure their weapons. But some gun owners have also said, we don't need new gun laws. We should just enforce the ones we have. Unfortunately, the existing law on gun storage is vague and unenforceable. If it were strong enough, we would not be seeing the numbers of kids getting access to guns to deadly effect on the rise. There were 23% more children injured or killed by guns in 2022 than in 2021 in Maryland. This is alarming and should be unacceptable. Without taking every step we can to protect our kids, what are we saying? That our guns are more important to us than our children? That the violence they must endure is just the price we're willing to pay for not taking gun storage with utmost seriousness? Our children are already burdened with more worries and traumas than we had growing up. Passing Jalen's Law adds an extra layer of protection to these young lives. Thank you.
Thank you very much. Delegate Bartlett, I also have Peter Benjamin, who is supposed to be part of your first panel. He's here. Do you want, what we could do is just have him come to the second panel, if that's all right? And is that all right with you? Okay, we'll do that. We'll have him go to the second panel, and then we'll go from there. We'll take questions now. Delegate Erican to begin, then Delegate Kaufman.
Thank you, Mr. Chair, and thank you, Delegate Bartlett, for bringing this bill. And I'll just say that when Jalen's family first came the first time and told their story, it made me as a mother go back to my house and look at my storage. So you've affected the lives of at least 4 kids already just by telling your story, so thank you. So I'm reading through this bill. I know you guys have actually done some work on it. It doesn't look exactly the same as it did the first year it came out. I still see in here that there's ammunition included, and I'm wondering if the sponsor would be amenable to changing that. Ammunition is almost impossible to store for families like mine that have large quantities. I would have to buy a lot of really big safes to store ammunition. Now, I have a big safe for guns, but it can't fit all my ammunition.
So I believe the requirement is that the ammunition is stored separately. Yeah, so that it's stored separately. So it doesn't have to necessarily be stored in the same method that the firearms are.
Okay, so the intent is not to have it locked in a safe, so it could be in a cabinet or something like that, but not in the safe with the guns? Is that the
Right,
idea?
it's not in the safe with the guns.
Okay, I understand. So if a child got into the gun safe, well, in that case, they would still have a potentially access to it if it's not locked up. Do you know what I mean?
Well, the key is to have the guns locked up.
Right.
That's the key, to have the guns locked up.
So maybe
because one without the other just doesn't work.
Right, yeah, the ammunition on its own
Yep.
is just like throwing a rock at somebody. So,
Mhm.
okay, so maybe there's a way to tighten the language so that is, so it's more clear in people that are, have a storage cabinet that doesn't have a lock on it or something. I mean, we have some in our garage, like, you know what I mean? It's really a large physical amount of things for some people, so it's hard for them to lock it up. And since on its own it's not a threat, removing that might be relevant. I'm trying to see. And then can you just talk through the penalties portion with me
Sure.
really quick? It says on page 4, so is this a first offense?
So
for D1, and then sort of just walk through what
Sure.
would trigger these subsequent offenses? Is that what I'm seeing?
So, essentially, we have to go back to, hold on one second here. We have to go back to the person who didn't store the gun properly.
Right.
Okay? And then we go to the person who didn't store the gun properly and that a prohibited person or unsupervised minor gains access to the gun and unfortunately there is a result in a loss of, there is a result of a loss. And actually, Karen, if you don't mind, could you, because I'm fading over
Yeah,
here.
no,
I'm
it's
sorry.
fine.
I'm sorry.
Happy
I'm
to,
trying.
happy to. No, so 3 categories. It's not stored properly is the first. The second is it's not stored properly, and someone who's not supposed to get hold of it gets hold of it. And then the third is that scenario with harm occurring.
Okay, so then in D, 1 corresponds with.
Yeah.
Oh,
that's
okay.
what makes it more
So
complicated.
the first issue, just leaving it out, is number 1. The penalty would be not exceeding 90 days and $1,000. And then the second is if they leave it out and somebody gains access, but there's no harm committed, and that person would get not exceeding 2 years and $2,500 or both. And then if somebody's actually injured because of it leaving out, then we come down here and we see not exceeding 3 years and a fine of $5,000. Is that
correct?
Okay, awesome. Thank you for explaining that.
Delegate Kaufman and Delegate Williams.
Thank you. Delegate Bartlett, can you hear me?
I can hear you. Thank you.
Okay. So, your bill is titled the Youth Suicide Strong Storage Requirement and Youth Suicide Prevention Legislation, Jalen's Law. And in your 3 minutes, and I assume it's because you were running out of time, you didn't articulate how this would help prevent suicides, which is very important to me. And so if you could do that. And also my second question is because you won't be up here during the opposition, is one of the opponents of your bill says that it infringes, it's an attack on his right to keep arms in our homes. So tell me why you think he's wrong.
Sure. So thank you for your first question. Thank you for both questions, but especially for your second question, because you're right. I didn't get a chance to get that far. So with respect to the suicide prevention piece, what we're asking is, first of all, when individuals, especially youth, do not have access to guns, then that reduces their ability, unfortunately, to conflict resolve through firearms. So that's on its face, I think is pretty clear. The other part is that we're asking the Secretary of Public Health, the Deputy Secretary of Public Health, to develop a youth suicide prevention program, and also along with that, tailor it to firearm safe storage, to a safe storage guide. So the whole point is to work with to have that public health approach, as I was mentioning, as we did with and I liken it to seatbelts, as we did in that circumstance to make people more aware. We give specific information that we want the Deputy Secretary of Public Health to include. And we also state, putting the guideline out there on the website, and then various behavioral health programs as well. And also within the local school system, which is key, because I don't know, I'm not an expert on this, but it does seem like in some circumstances, we are finding that it is becoming a conflict resolution mechanism instead of being able to actually try to resolve conflict in a non-violent way. With respect to your second question, I will state that some have interpreted the Second Amendment to be a right with respect to firearms, but with that right comes awesome responsibilities. And as Delegate Erica had mentioned, I appreciate the fact that she was saying that she was touched by Ms. Willie's testimony over the years, and that's what we want. We want people to store your firearms safely. Under the bill, the firearm, as I stated before, has to be stored separately from the ammunition. The firearm must be unloaded and inaccessible to children under the age of 18. That's key. Currently, I think it's 16. And so we believe that this is not an enormous burden even though the opponents may argue that it is. Again, like I compared it to seatbelts, remember that taking a few extra seconds to put on a seatbelt, roll up your sleeve for a polio vaccine, or avoid smoking with children or when you're pregnant has saved lives. We know that, and so that's the whole purpose of the bill.
Mr. Chair, could I make a comment about the suicide piece? Would that be okay? I think that's such an important question, and I just want to point out that there's data that demonstrates that 75% of youth firearm suicides for which the gun storage method could be identified, they found that the gun was stored, loaded, and unlocked. And we know when you look at those that decide to attempt suicide, after the decision is made, 70% happen within that first hour. So after they've made that decision, it's too late to intervene. And on top of that, we have seen an increase in the suicide rate in both Black and Latinx. So, you know, there's many reasons that we need to focus on secure storage, and thank you for bringing up the suicide piece.
Thank you, Mr. Chair. That concludes my questions.
Delegate Williams, please.
Yes.
Then Grammer.
Thank you, Delegate Bartlett, for bringing this bill. As you know, I'm super supportive of this. But I did notice with some of the testimony that was submitted, one was from, I just wanted to bring this to your attention, and if you have a comment, to definitely comment. One was from the Department of Health, just asking for an amendment as it relates to kind of greater flexibility and as it relates to the Deputy Secretary. I don't know if you saw that or not, if that's something that you're open to.
Indeed, I am. Indeed, I am.
Okay. And then also I noticed the testimony from the Maryland Network Against Domestic Violence, as well as the Women's Law Center, also asking for an expansion, an amendment as well, just to also include in the list of prohibited persons pursuant to 4-506 of the Family Law article.
Yes, in fact, let me just go back to that section. I don't have any opposition to doing that. So that's the bottom line. I was going to look at it in the prohibited person in here, but I don't have any opposition there.
Okay, thank you.
Here we go. Yeah.
Thank you, Mr. Chair. For Delegate Bartlett, I thought the analogy that you made to seatbelts was very interesting. So going back, I remember being young, and there were a lot of public awareness campaigns in my district. They used to kind of match it with drunk driving, and they would take a car that had been in an accident, and they put them on the schools. So it kind of became like this big buzz, like wear your seatbelts, don't drunk drive, and then your mother would hit you every day. You're going to get your seatbelt on. And I'm more inclined to say it was attitudes that changed rather than the law. I am not compelled, with the fact that we changed the law so people will now wear their seatbelts.
But you know how the attitude changed? Do you remember? Were you? I'm not sure how our age difference is, but let me just tell you, give you a little bit of history. They actually, at first, you have to wear your seatbelt. People weren't wearing them. So then we manufactured cars, we meaning, America, manufactured cars that automatically would put the seatbelt on you, okay? And so slowly people started to catch on, I better wear my seatbelt. Then they decided, okay, I'm not going to wear the harness, the shoulder part, I'm just going to wear the bottom part. And then we started to see, wait a minute, people are still dying. One of the first questions people would ask when there was a car crash and there was a fatality, were they wearing their seatbelt? So that's how the attitude changed. And then eventually, even now with the cars, they will beep. They will beep if you don't have your seatbelt on.
That's annoying as anything.
And it's annoying, and that's how we change the attitude. That's how the attitude changes. Unfortunately, behavior doesn't change automatically, and we know this. So it changes over time, and that's why I had to go all the way back, to try to tell the history.
I continue to challenge that because I've never been in a car with one of those seatbelts. I've been in a car with the beeping, but that didn't happen until, for me, the last several years. For me, the change happened back in the 80s when people started to say, don't be stupid. They were actually changing opinions about drinking beer in cars. I saw a video recently where people pitching a fit. They couldn't drink a beer in a car. So it's germane here because the question always becomes, how do you enforce this? I'm looking at the physical note here. And so this section of law exists. you're changing some of it, but there are enforcement mechanisms here. In district court, there were 69 charges with 1 guilty finding. In circuit court, there were 45 charges with 4 guilty findings. So for me, it's one of those subjective things, like the question in my mind, you could put 20 years on this bill. Like,
You think we should?
how do you, the question is, how do you legitimately enforce this? Because what you're saying is this law applies to you in your home. You have to do this. That's the law. Well, then what?
Well, compare it again to I'm going to make that comparison again to the cars, okay? We don't know if you're riding around with your seatbelt on or not. We don't know until the police officer pulls you over, okay? And then we know, or until there is a fatality. And then we know. We don't enforce it by telling people, by checking cars on, at a checkpoint every day to see if they're doing this. And the car is not even as much of a sanctuary as your home is. But the point is that it's the result where we learn that this particular person did not do X, Y, and Z. Dr. Sacker, I'm sorry, you wanted to say something, but that's how we know. We know from the result. The enforcement mechanism is just as we have with anything else on the books. It becomes a deterrent. If you are recommending 20 years, then so be it. Let's go 20 years. And I know you're not. I'm just going to take that for a second.
But that's my point. We know a large amount of the gun crimes come from straw purchase. It's not only is it, we have some numbers regarding this.
But it's not the purchase that we're concerned about with this particular bill. It's the storage.
I understand that.
Yeah.
But the point you're getting at here is trying to reduce crimes related to gun storage and access, et cetera, et cetera.
Trying to reduce deaths.
Yeah. Oh, yeah.
Deaths.
Absolutely.
Yeah.
And to me, it seems like one of those moments where educating people as opposed to, look, we have to go home at the end of the session and say, we passed these laws, now it's going to be safer. And I just don't see it, because no matter how you rearrange this section of code, I don't see how you enforce this.
Sorry. Okay. Well, I'll tell you, I understand that, but, we said the same thing back in, 1967, okay? And we know through a public health component, we know that we can reduce deaths. And Dr. Sacker, I think you wanted to respond.
Yeah, is that okay, Mr. Chair? I think it's a very fair question. I think, when you look back historically, right, in the 60s and 70s, when we had the car fatalities, it wasn't one thing that happened, right? We didn't get rid of cars, but what we did is we came up with seatbelts, we made roads safer, we came up with airbags. So we moved away from simply trying to, focus on changing human behavior, which in and of itself is not cost effective, and developing a system that makes it less likely for people to be injured. And the cultural transformation that happened, as you heard the delegate describe, took decades to happen. I mean, the first thing that you see right now in Hollywood when an actor gets in a vehicle is they put their seatbelt on.
Yeah.
That's not a coincidence, that's intentional. The other thing I would say is that when you look at other states with child access prevention laws, the academic research demonstrates that they're associated with a reduction, right, in these injuries and deaths. So, there's no one solution to a public health approach, and I think your questions are very fair. We have to approach this in a multifaceted way to try to do the best that we can to protect citizens of Maryland.
Thank you.
Thanks for the question.
Thank you, Mr. Chairman. Thank you, delegate and witnesses, for coming in to testify. So, Delegate Bartlett, I appreciate you welcoming me to school, but I think you kind of missed the part of the seatbelt law while you were telling the history. The shoulder part of the seatbelt law now was mandatory at one point, and the police officers could ride down the highway and look in your car and see if you had the seatbelt on and make a primary stop. I noticed because I have on a jacket that's kind of tender, and if you're moving, that seatbelt will rub a mark underneath on top of your material. So if you put your arm over the belt, and the belt is underneath your arm, they'll pull you over, and then because you made contact, they'll give you a warning for improper use of safety equipment. Okay?
Thank you.
So then it became not a primary stop.
Mm-hmm.
But I was wondering, how does a homeowner in a high-risk area of home invasion how do they prepare themselves for a surprise under your bill? In other words, in certain areas, any type of crime is subject to breakout at any time. Someone could run into your house, or maybe chase one of your children into the house, or maybe chase your spouse into the house, that type of thing. So how do you stay prepared for something like that, and not being insensitive to the suicide prevention part of the bill? And I appreciate that part, but there's certain people that might not want to speak out against this bill because of the title, but they're going to say, I'm going to keep my gun loaded anyway and right near me. And they might go upstairs while they're cooking, leave the gun downstairs by mistake, children in the house. How's the person deal with that?
Thanks for that question. Karen's going to answer that question for you.
Yeah, if you don't mind. So this bill doesn't do anything to say that you cannot use your firearm for self-protection. What it does is say that if you don't have your firearm on you, if you are not in complete control of it, then it needs to be stored properly. So it isn't okay to leave it on the counter downstairs when you run upstairs to go do something, especially if there are children around. That's simply unacceptable. And if using it for self-defense is your priority, then you choose storage methods that you know you can access very quickly. And there's lots of videos out there you can look at. There's lots of new storage methods out there that you can get into as quickly as you can open a drawer if you were keeping it in a nightstand. So you treat that as part of your firearm safety training, like
so
you would.
I thought that the firearm has to be stored separate from the ammunition.
From the ammo, right? So yes, it does. If you don't have it on you, if you do not.
How much time are you talking about?
Seconds. It can be seconds.
So if you're downstairs and you're moving around between your first floor, your basement, and all like this, you need to have that weapon stored upstairs, maybe in the box where it should be, and ammunition somewhere
You can have it stored on the first floor, the second floor, the third floor, and the fourth floor. It just has to be stored, unloaded, and it has to be properly stored, and the ammunition has to be separately stored.
And do you think the average firearm owner is going to comply with this if we pass it?
You know what? I don't see why not.
Oh, you don't? Okay.
Nope.
Thank you.
Well, I don't know the order, but I'm going to go Delegate Tolles and then Simpson.
Thank you. My watch said it's time to stand. Okay. I just want to thank Delegate Bartlett for bringing this bill. And I think it's extremely important piece of legislation. It reminds me of going back to my local government roots, where carbon monoxide was, not necessarily required in homes, but we know it was a silent killer. And, after a while, it got to the point where it just became so prevalent that it became mandatory that new homes were required to have carbon monoxide detectors in homes. And even now in older homes, along with your smoke detectors, you can buy them, or the fire department, at least in Prince George's, will put them in for no cost. Sorry if they're listening, I'm giving you guys and gals work to do, but they put them in for no charge, both the smoke detector and the carbon monoxide. And it reminds me of that level of protection that was necessary, that layer that was added because of so many, deaths that occurred through carbon monoxide. And, Jalen's mom, as well as, the gentleman that got shot, I am, adamant about the fact that you have a responsibility to not only protect your children, but other people's children in their homes. And it's, I think it's important that that's done. And, for those that are in opposition, we have a responsibility to protect our neighbors as well as our own, children. So I think creating this plan by 2024 is necessary. It should get to the point where, let me just ask this. Let me make it a form of a question. Do you believe that there is a way, could you offer ways that, like I indicated with the carbon monoxide detector, something can be done to ensure that homeowners, maybe when they purchase the gun, or, constant, a way to check to see if they have storage, or even be held accountable if no storage is in the home?
Well, I will say, and you will hear the opponents say this, and I appreciate this, and that is that some of the gun owners they actually teach. They teach storage. This is also part of your training, because I did ask that question when we had the troopers here. I think it was the troopers. But I asked, are they taught storage as well? And is that something you have to pass in order to get your permit? And they said that it was. I'm sorry. And they said that it was. So I think that's one way, is to continue to teach proper storage. Continue, as we update the law, you've got to update the training. Curriculum cannot be stagnant. And so that's how I feel about that. I don't know if anybody else wanted to add anything.
Thank you.
I mean, I think that's what the education component is designed. I think that's what the education component is designed to at least start doing, and to allow a process for assessing how well that's being done and what could be more effective about it. You start by getting the law in place and rolling out, what the standard practice needs to be, and then grow it from there. And there's an element of the education component that actually talks about getting the information out to parents in the school system and that kind of thing. So I think that could be an evolving thing over time as we see what's effective and not effective.
Thank you, Mr. Vice Chair. Just a follow. Oh, Mr. Chair, hi. You're back. Great. Just a follow up. Is there some way that that this branding will be done as well as during the purchase of guns, like the materials and everything as well? I see you have it for, and you indicated for schools and getting information out in local health departments, but getting it into the hands of people that actually purchase it in the gun shops.
I think we're trying to be somewhat careful there, because I know that there's some lawsuits going on in Anne Arundel County about putting literature in gun shops and what's required in that regard. So treading carefully to make sure we don't step on any First Amendment rights, but trying to make sure that the information is getting out there. I have this dream that I'm going to drive into Baltimore and see it on billboards at some point, someday, but, we'll see.
Thank you. With your continued advocacy, I'm sure we've got to get to the point like carbon monoxide is common, is natural, but to have it.
Yeah.
Thank you. Thank you, Mr. Chair.
Last question for this panel, Delegate Simpson.
Jalen's mom, I will say that I am so glad that you have taken your grief and turned it into advocacy. I know when you lost your daughter, it was very, it impacted me as a domestic violence survivor. And I just really, really appreciate you being here and turning it into making a difference in all the different ways that you can. And I did see in here that there is the piece about making a guide and the educational piece. Going with Delegate Brammer, have you thought in terms of, hey, that cute video that's, making it a little bit more widespread, perhaps a commercial, like you said, a billboard that moves, whatever, that, because, it really needs to get into the hands, I think, along with the same thing as Delegate Arkham, knowing that people knowing. I know I've had neighbors who've had issues where they've had break-ins and stuff. It's not just about those kids, because people have kids that come over their house, but not necessarily the school. It's not necessarily just the parents knowing, but it really is a really important issue. One of those things, just like the seatbelts, people weren't necessarily thinking about.
Yeah.
Whether it be amended, to go a little bit more widespread in the educational piece.
And I appreciate you saying that. And yes, we will continue to work with that, with the education piece. Keep in mind, as I mentioned, and we only had 3 minutes, but there is a whole national comprehensive public health comprehensive approach to safe gun storage or to reducing gun deaths. And I will share this with you, but it literally takes car crashes and gun deaths and shows how this was done in this circumstance, and this can be done in preventing gun deaths, all the way from manufacturing standards to age requirements, license renewal, which some of the things we already have in place. So, yes, the work is being done, the research is being done, and I appreciate the advocates for looking at it through a public health lens, because I think that's the only way we're going to be able to kind of tackle this problem.
Right, and come together.
Yeah.
Thank you.
Seeing no further questions for the panel, thank you very much. We're going to hear, I'm sorry. Okay, wait a minute. Delegate Valentine, go ahead. Let's try and keep them close. Go ahead.
Just one question regarding the fiscal note. I just want to confirm because I'm not clear. For the mandated funding portion, is that directly related to the health portion of the bill?
Yes,
Is
I
that
believe
related
so.
to that?
Would you agree, Karen? I believe so.
Sorry.
The mandated portion is for the health-related,
It is.
yeah.
Thank you.
Yeah.
No further questions. Thank you.
All right.
Thank you.
That concludes this
Thank you,
panel.
Mr. Chair. Thank you.
All right, Peter Benjamin, Cheryl Brooks, Cheryl Bost. Is Liddy Ballard on virtually? Don't see them on virtually. Greta Willis is on virtually. Mr. Benjamin, go right ahead for 2 minutes, please.
Mr. Chair, Mr. Vice Chair, committee members, I am Peter Benjamin. I live in Garrett Park, District 18, and I'm a member of Marylanders to Prevent Gun Violence. Just over a month ago, a 6-year-old child at Richneck Elementary School in Newport News, Virginia, took a gun from his mother's closet to school and shot his teacher. Too often, we hear of a minor who takes a parent's gun to school and shoots classmates and teachers. We remember Sandy Hook. Too often, an angry minor, despondent over an ended relationship, uses a parent's gun to express their anger and loss by killing a former close friend. We remember Jalen. Too often, a depressed teen uses a parent's gun to commit suicide. We remember Sydney Aiello. Too often, a young child plays with a parent's gun, not understanding that it's real and loaded, and shoots a friend by mistake. This must stop. So I support HB 307 to legislate requirements for gun and ammunition storage. I urge a favorable report on HB 307 to keep guns away from minors who should not have them. Thank you for giving me this opportunity to speak to you.
All right, here's what we're going to do with respect to the State's Attorney for Howard County is favorable with amendments, which is fine. We're going to hear from everybody else, and we're going to hear from you, and then including the person who's here virtually, so that we can kind of keep some kind of order to it, and then we can hear about your amendments at the end, too. Go ahead, please.
Good afternoon, Chair Clippinger, Vice Chair Moon, and members of the Judiciary Committee. My name is Cheryl Brooks, and I reside in Westminster, Maryland. I am in favor of HB 307. I am a parent who lost a son to suicide. My son was 30 years old at the time of his death. Yesterday was the 9th anniversary. I often wonder, though, excuse me, if I would have lost him as a child or an adolescent, if I would have had an unsecured gun in my home. Michael was never diagnosed with a mental disorder, so I would have been unaware of any suicidal ideation. With our now ever-increasing gun ownership, along with an increase in mental health issues, we as adults need to implement policies that limit easy access to lethal firearms to children and adolescents. Suicide is now the 3rd leading cause of death for young Americans. Secure storage of guns is a common sense approach to prevent these tragedies from occurring. For these reasons, along with the increase in unintentional, accidental gun injuries and death, I ask for your support in passing HB 307. And thank you for your time.
Good afternoon, Chair Clippinger, Vice Chair Moon, and members of the committee. My name is Cheryl Boast, and I'm a 4th and 5th grade teacher, proudly serving as the president for the Maryland State Education Association, representing over 75,000 educators across Maryland, and speaking in favor of House Bill 307. I say respectfully, I wish we never knew about Jalen in this way. I wish we knew that she was off living a happy life. The same as I wish we didn't know the names of students who were murdered at Sandy Hook, Uvalde, or the 1st grade teacher in Virginia shot by a 1st grader. We can name way too many children who have been killed by firearms in our communities. We provide thoughts and prayers to families, yet the next time media coverage decreases, thoughts and prayers diminish. But the trauma remains for the families who have lost loved ones, for the educators who try their best to protect classrooms of children or deal with the loss of classmates, and to the entire communities who never get over the trauma inflicted upon them. Millions of fans, like me and many of you, we watched Buffalo Bills player Damar Hamlin pass out and be brought back to life using CPR and an AED. Soon after that, legislators across this country brought to the forefront to equip gyms and fields with AEDs, and employees were required to do CPR. In the 1980s, children under 18 were primarily killed by car accidents. Today, everyone in this room, children or grandchildren, you strap your children into regulated safety car seats. Why? Because we know the seats protect the lives of our precious children, and there are laws requiring them. Today, firearms are the #1 cause of death of children in the United States. Additionally, the firearm suicide mortality rate among children in the U.S. increased 13% from 2019 to 20. Please don't wait. Let's do something to turn the tide. This bill is the least we can do to make sure firearms are kept safe, students learn gun safety procedures, and we protect our students and families from trauma. On behalf of educators, students, and parents, please vote favorably for House Bill 307, and let's send Jalen's law to Governor Moore's desk to be signed into law this year. Thank you.
Thank you. We'll hear now from Greta Willis, who's on virtually, and then we'll go from there. Ms. Willis, please.
Good afternoon, Mr. Chair and members of the Judiciary Committee. My name is Reverend Greta Willis. I am a Maryland resident. I am a mother. I am one of the members of the faith-based community that works closely with families in our community in Baltimore City. A families has been affected by gun violence, especially back in August of 2022. A 9-year-old was able to remove his grandmother's weapon that was unsecure and shoot and kill a 15-year-old who would never get to graduate, who would never get to have a family of her own. There has been so many collateral damage left to the family as a whole. So I favorably support this bill, House Bill 307, because firearms and safe storage should be for everyone. Keeping it away from the children we know that there's common ground on both sides of the gun debate. Only the gun comes with responsibility, and unfortunately keeping those guns packed in a way that they will be safe away from children. So I will be favorable unto this bill, and we must take action now so that our children can live and grow to become productive citizens. Thank you all for your time and support for me being able to speak during this time. Thank you.
I think we got most of it. We really do appreciate hearing from you. Okay, so now we're going to hear from the state's attorney from Howard County. He's here favorable with amendments. He has another engagement he must go to, and so we want to give him the courtesy. So for 2 minutes, please.
Thank you very much for the opportunity to address this committee. My name is Rich Gibson. I'm a state's attorney for Howard County. I've been a prosecutor for 19 years, And I really appreciate the fact that the sponsors of this bill have brought this bill forward. It does a ton to address an issue that is impacting so many lives in our county, in our state, in our country. Right? It just forwards the logical goal of keeping dangerous and deadly weapons out of the hands of individuals who shouldn't have them, and it avoids the foreseeable consequences that comes from a child or a person disqualified of a crime getting their hands on a weapon and then engaging in a terrible result. One suggested amendment I have that would enhance the usefulness of this bill is to add the amendment that if there was a conviction sustained under this law, that it would be considered a disqualifying crime under 5101, prosecutable under 5133C. That would enhance the effectiveness of this bill for prosecutors. One question I've been asked in preparation for this is, will prosecutors use this? And what about overzealous prosecutors, people who are going to pursue cases to draconian results? One, prosecutors will use this tool if it's available to us. And two, we are elected because we reflect the values, thoughts, and judgments of our community. People in our community trust us. That's why they put us in these positions to use our judgment. In instances where pursuing a particular charge would result in a draconian result, we don't need to pursue with the charge. Right? We have discretion. We have judgment. However, in instances where there's a greater harm and a larger public safety issue, we, of course, will pursue with the charges. I'll take any questions, and I support this bill and ask that you find it favorable with amendment. Thank you.
We'll take some questions now. Questions for the panel? Delegate Valentine.
Thank you, Mr. Chairman, and thank you all for coming today. I did have a question with the amendment, so just so that I heard you correctly, a proposed amendment on your behalf and from yourself. So if you are charged and convicted under this statute as written, that would disqualify you from owning firearms in the future. Is that correct?
Yes, I'd like to add a conviction to this statute to the disqualifying crimes. And the rationale behind that is if you were irresponsible with the gun in the first place, you've probably shown a penchant for not handling weapons properly, and therefore you shouldn't be someone who has weapons in the future.
Thank you for clarifying that.
Further questions for this panel? Okay, Delegate Pasteur.
Thank you, Mr. Chair. This is to Ms. Bose. It's good to see you.
Good to see you.
Tell us, please, what you think from the education side could be done along with this, keeping in mind whatever pushback you think you might get. But we always start in school systems in Maryland with MSEA. So what kinds of things, just as with seat belts, carbon monoxide, everything else, there's always been some sort of school initiative, parent initiative, even with our smallest children, just little things, and often we know that it's our children who go home and remind parents of what should be done. So what do you see can be done along with this? If this is passed, or when this is passed, what could be done so that we can move this paradigm and make these changes?
Thank you, and great to see you this afternoon. Education is the key to a lot of this. I mean, the security of it, but as you said, many of our students come back and tell their parents what they're supposed to do and for safety and eating healthy, all of those things. Our kids come back and tell us. I think it'll go a long way to provide these resources that are outlined in the law to our schools on safety. And it includes the pieces on the suicide prevention, which we see is on the rise. The two often go hand in hand. So that's why I think it's good that in the bill they go hand in hand. When Delegate Grammer talked about changing the hearts and minds, it starts with education. And so that's why the education piece in here. I remember as a fourth grade teacher, we had the police heat band who would come into my elementary school and they would talk to kids about safety And that doesn't exist anymore in our school system, but to ramp this up, we could make it a fun way, an educational way, even for our youngest learners. And that's where it starts, and that's what begins to change the tide for anything that we put in place.
Thank you. And with that, you do now, have the infrastructure to make things happen. We've had DARE officers. We still have SROs or whatever they might have in like Baltimore City. That's a little different. But it makes, would you agree that it's a friendly opportunity to have those officers who are in the schools to talk to children and have children see them differently and to soften it, but to make it real for them?
I think it's a good way to have lots of people to come in and talk to students. And there's lots of organizations. You talked about DARE. There's MAD. There's other items that deal with various issues. And all of this can be, they can collaborate to make it a safer environment.
Thank you.
Delegate Tomlinson, then I have a question.
Chair, this question is for State's Attorney. Nice to meet you.
Pleasure.
I think you said this in your oral testimony, but I'm definitely reading it in your written. Could you kind of expand on what you meant by, or what you said or meant by possibly pursuing charges against family members who improperly store weapons and it leads to a self-inflicted injury or suicide?
So yes, there was shared with me a concern related to an individual who, let's say a parent has one child and they stored a gun improperly, and that child unfortunately got a hold of the weapon and, did the most horrible thing and took their own life, right? There's a question as to whether we as prosecutors would be eager to prosecute that parent under this law. It's important to understand that prosecutors' mission is to do justice. All right, it's not to get convictions. Our mission is to do justice, to try to find out what happened and then marry the offense and the facts to the law, and then produce a result that makes the society safer. In that instance, each case looked at like on a case-by-case basis. In that instance, that parent is probably in the worst possible place they could ever imagine being, and you can't punish that person any more than they're already being punished by life, fate, the universe, whatever, however you want to look at it. And so to add on to that, to pile on to that, would not be consistent with justice, generally speaking. Now, there are 24 state attorneys, but I'm the president of the association. I'm speaking today just as state attorney of Howard County. But I think that most of us, all of us, endeavor to do the right thing. Conversely, if you had a circumstance where a parent, same fact pattern, gun not stored properly, parent has 5 other kids, all right? If we don't take action, those 4 other children and the community they interact with are in jeopardy. And so the analysis might change depending upon the tweaking of the facts. But single child lost probably would err on the side of not prosecuting that offense. That's what I meant to say.
Gotcha. All right. Thank you, sir.
You're welcome. Thank you.
Very quickly, hopefully, but probably not for the state's attorney. Second dream.
Chairman Klobuchar.
Yeah, well, in the bill, it changes the language. Person may not store or leave. It strikes the word loaded. It would be leave a firearm in a location where a person knew or reasonably, adding the word reasonably, should have known that a prohibited person, and it goes on. It adds that reasonably language. Can you talk, and if you can't, if I'm catching you out here, that's fine. The distinction between just should have known and reasonably should have known, and why that's important or whether it's not important. I just would like you to talk to that.
Right. So in the law, we look at proving given elements. At our level, it's beyond reasonable doubt. That's the burden of proof we have to meet. And the question of reasonable is determined by what would an ordinary person operating in that condition consider to be likely versus a unique fact pattern that is just a one-off. And so if the gun is stored in a place like the kitchen table, loaded, just sitting there, all right, it is reasonable that a child who walks by that can see that gun on the kitchen table and interact with that gun on the kitchen table, right? Versus if it was placed someplace that the parent believed was, secret, and a reasonable person looking at the same facts would also agree that the gun, while maybe not locked away, is stored in a way that is secret, and a reasonable child and a reasonable person would not think that a person who shouldn't have access to this weapon would have had access to the weapon. It would change the criminal liability. So reasonableness relates to the objective standard that we have to show, and a jury and or a judge, depending on who was in front of, would have to agree that it was objectively reasonable that this item was stored in a way that was likely to land in the hands of someone who shouldn't have it, whether it be a child or a disqualified individual.
Thank you very much. Any further questions? Seeing none. Thank you all very much.
Thank you.
All right.
Thank you very
much. I'm going to go now. Liddy Ballard from Brady was supposed to be on virtually. I don't see her, but we'll keep an eye out for her. Hear from Eileen Zeller, Woody Kessel. At the table. Okay, Leslie Bigden, Nicole Hollywood, Sarah Edwards. If we need to add another chair, we will. Okay, everybody whose name I called is at the table or going to be at the table. That's fine. Let's begin again. First on my right, your left, and go across. Go ahead.
Hi, my name is Eileen Zeller. I live in Howard County, Clarksville, Maryland, in District 9A. Thanks for the opportunity to present today. I'm speaking today as a volunteer for the Maryland chapter of Moms Demand Action and as someone who retired after a career in suicide prevention and public health. In retirement, I also am chair of the Governor's Commission on Suicide Prevention, and I'm on the board of the Mental Health Association, but I'm here just representing moms. And Delegate Kaufman, I'm going to be talking about suicide, right? So research consistently shows higher suicide rates among people who live in homes with firearms. And that is not, I'm from a gun-owning family, okay? It is not because gun owners and their families are more suicidal. It's because if someone in your family becomes suicidal, they then have access to the most lethal means possible of attempting suicide, of killing themselves. So some people take their lives after very careful planning and deliberation, but for many others, as the Hopkins physician said before, suicide attempts are impulsive and they're driven by very temporary life crises. Studies that interview people who survive suicide attempts report that even though they may have considered suicide for days or weeks or months ahead of time, the actual decision comes within an hour or even 5 minutes of actually making the attempt. That's especially true for adolescents. And so the method they can get their hand on, that determines life and death so often. If parents can prevent access to a firearm during that brief period of impulsivity, they can prevent the attempt or drastically reduce the lethality of the attempt and the chance their child will ever go on to kill themselves. No parent should go through the agony, but between 2016 and 2020, we lost 178 Maryland adolescents to suicide. Those families are never going to recover. The part that I love about this bill is that we can educate parents how to keep their children safe, and I believe HB 307 will do that. So thank you for your support.
Good afternoon, Chairman Clippinger, Vice Chairman Moon, and members of the committee. My name is Dr. Nicole Hollywood. I live in Salisbury, Maryland, in District 37B. I'm a volunteer with the Lower Shore Local Group of Moms Demand Action. I'm also a gun owner, a survivor of gun violence, a mother, and an educator. I took the day off work from my university and committed myself to a long drive from my home in rural Maryland because I support HB 307. I support HB 307 because I have teenage sons who lost their veteran and law enforcement father to suicide. Sorry, it was recent. And I know that secure storage can reduce instances of suicide and save lives. As a responsible gun owner, I also understand that it's a myth that storage devices put barriers between the gun owner and their means of defense. There are many affordable options for firearm storage, such as biometric safes, that provide owners with quick access to their guns while still preventing access by children and people at increased risk of harming themselves or others. My family personally stores our firearms unloaded, locked up, and separate from ammunition, and we know that with rights come responsibilities, and secure firearm storage is integral to public safety. I ask the committee to issue a favorable response on HB 307. Thank you for your time.
Good afternoon. My name is Sarah Edwards, and I'm a child and adolescent psychiatrist at the University of Maryland Medical Center. Suicide is the second leading cause of death among youth ages 10 to 24. And we know that most suicide attempts happen with little planning during the midst of a short-term crisis. Please consider these two examples. A 14-year-old boy who's been feeling down and sad for several months suddenly becomes upset because despite studying for his midterm, he fails it. He looks on social media and he sees that his girlfriend is following some other peer. He has overwhelming feelings of being in failure and disappointment, so he goes to his father's nightstand and he overdoses on his father's blood pressure medication. His parents find him, they take him to the hospital, and he receives medical care and psychiatric care. Now imagine that exact same scenario, except that when the youth has intense feelings, he now goes to his father's nightstand, and instead of blood pressure medication, there's a gun, and he shoots himself. He's taken to the hospital where he receives medical care, but he suffers fatal wounds. Reducing access to lethal means of self-harm saves lives. Families, organizations, and policymakers must take action to reduce access to lethal means, and House Bill 307 supports important fire safety precautions. Thank you.
Good afternoon, Chair Clippinger, Vice Chair Moon, members of the committee. My name is Leslie Bigden. I live in Severna Park. I'm here to testify on behalf of Jalen's Law, HB 307. I'm not an expert. I am not a doctor, but I do know what this family is going through. You live with a hole in your heart. You live every day in fear. Every single time. I mean, Michigan just came out. This is the 67th mass shooting this year. I mean, I just don't know when it's going to end. My nephew was killed at Sandy Hook. He would have been 16 years old this year. Okay? Why haven't we done anything? We need to do more. This is not acceptable. We live in a civilization where everyone is in fear. And there's excuses made. There's maybe verbiage that we disagree on. But this is ridiculous. This is, I think, the 7th year that I've been here. I'm tired. I have a family. I'm sick of being here past this now. Done.
Thank you, Mr. Chairman, Vice Chairman Moon, and delegates. You know, my name is Woody Kessel. I'm a pediatrician. I've dedicated my life to the care and well-being of children, to disease prevention and health promotion. How can the epidemic of gun violence be raised? And now it's the #1 cause of death in this country and in this state, and we can sit here and debate. We need to do everything we can do to not be complacent, not be contemptible. You know, I started my testimony in a classical academic way, but the passion of my colleagues and of the other witnesses just have moved me. You know, we've done well with safe storage with medications. As a senior, we didn't pass a law. We changed the caps. Kids are smart. They're curious. They can get into things, so we made it more difficult. We had Mr. Yook campaigns. We hid things and locked them under the sink and educated our children about what was harmful. with cleaning materials. We build fences around pools. We secure our kids in automobiles, in car safety seats and seat belts. Now, yes, the law did help. It was an encouragement, but largely the encouragement came from a generation of children. I'm sorry, Delegate isn't here, but it was now the children reminding the parents, I'm not in my safety seat. We've changed the culture in this area. The tragedies of the last few days remind us of how compelling this needs to be to stand up and do something. We favorably support this bill, and in particular, the education component, to try to prevent the lethal consequences of the youth that are struggling in our community. It's an epidemic across our country. Thank you, Mr. Chairman. We urge immediate action and strong action here.
Thank you very much. Delegate Cardin with a question.
Thank you very much. Very quickly, this is actually to the young lady from University of Maryland. You're going to have to go to the microphone, unfortunately. But first of all, thank you all very much for your incredibly compelling and heartfelt testimony. It really is impactful. This bill has been in for years, and I know that Delegate Bartlett's been helping out, but Delegate Stein's put this in for years. And it started out with just like 2 or 3 different groups. I think Moms was just being created at the time that he first put it in, like 5 years ago. And you gave the example of somebody who did something that was harmful to themselves, but you were able to reverse the effects. And guns cannot, and therefore there has to be a special premier amount of safety in terms of how you handle it. Can you just discuss, because that's the essence of this bill, to me, is the safety of children. It's also the safety of everybody. How effective are you and your institution and the people like you at reversing the insecurities and the inequities of these children if you have the opportunity to do it, so that we can have a reason to say, if we can stop them from getting hold of the gun, we can actually reverse all the damage that's being done to them? Does that make sense? I mean, again, it seems to me like if you get hold of these children, you're going to be able to manage the issues that they're having.
Prior to being in a state of distress and emotional, absolutely. We know that education, we've been talking a lot about schools. We start early with social emotional learning, giving kids the vocabulary to identify feelings, and then providing them with appropriate coping skills so that they understand what to do when intense emotions happen. And we've been doing a great job of that. However, look around right now. 1 in 5 youth have a mental health diagnosis. We could talk for a long time about why that is currently with social media, the stress from the pandemic, many reasons. But there's definitely, we can, and we do good help. All of these different organizations here, we know that prevention works. And so from a health perspective, we definitely need to be putting our time and energy into prevention. And so we've been doing it, and there's many ways to help support all of our communities to make sure our children are as successful as possible.
Any further questions?
Mr. Chairman, if I could just add
briefly
to the delegate's question. President Darrell Pines of the University of Maryland here in College Park has taken the leadership to summon 20 of the other university presidents in our area to take on gun violence prevention as a serious challenge, and bringing all the academic, the community, the service programs, and because of Darrell's background as an engineer, he wants them actionable. So the notion of taking this to the community and looking at every opportunity to prevent mental health at its roots, not during the impulsive part when the gun is available or other lethal means, but to deal with the root causes of many of these concerns that challenge all of us in the community. So it's another activity that shows that this region and this concern has risen to the awareness of our presidents of 20 universities in this area.
Seeing no further questions, thank you all very much. All right, I'm going to hear from Mike Song, who is on virtually now. Addison Willie, Aaron Willie, are you still here? Still, come on up. Sorry, say that again? Okay, thank you.
Can I sit with them?
Yes, of course you can. Sarah Edwards, I'm sorry. That's right, I beg your pardon. Just trying to keep track. All right, I'm going to hear from the Willies first. We'll hear from the two of you, and then we will hear from Mr. Song, and those are the witnesses that will complete those testifying in favor. Who would like to go first?
Addison will speak first.
You walk around school all day, you go to your classes, talk to your friends, teachers, whoever else. You go to school the next day, and something happens at the school your siblings go to. You don't get a call or text from your parents, because they don't know what has happened either, but you find out what happens before they tell you on your own. You find out there was a shooting at Great Mills High School, and your sister was the victim. This happened on March 20th, 2018, almost 5 years ago. My sister was shot in the school. Me and my peers walk around in every day, Monday through Friday. On March 22nd, 2018, my sister passed away. For almost 5 years of my life, I've had someone missing in my life, and so many other people have around the world with their family. Hi, my name is Addison Willie. I am 17 years old, and I want to help make a difference in the world. School shootings affect everyone. They affect the families, the people in the school, and people who hear about them. On a survey I conducted, one of the questions was, when you hear a school shooting has happened, how do you feel and why? One of the responses I received was depressed and grievous. Nobody deserves to go through that or have to live with the aftermath, but knowing school isn't a safe place and a reminder of what someone has lost. Another person that I received a response said, sad and angry that there isn't enough done to prevent them. People always think it won't happen or it's not going to happen where I go. But it did happen, and it can happen again. School shootings are something that make people think that going to school is unsafe. By going to school, you don't know what could happen. Between the years 2015 and 2018, on average, the amount of days that went between a school shooting was 77. 77 days. That means every 77 days in schools, families, friends, and so many other people were in the situation no person ever should have to be in. The longest gap was 1 year and 6 months, from April 2001 to November 2002. That was over 20 years ago. Alfred University did a survey on why people think school shootings occur. The number one reasoning is 87% of people who took this survey said they want to get back at someone who hurt them. 86% of people agreed with other kids pick on them and make fun of them or bully them. 56% of people agreed with they have mental health problems, and 18% of people agree with they are bored. We've been in the year 2023 for 46 days, and there has been 71 mass shootings. There has had to at least have been 2 mass shootings every day this year, and that does not include the smaller shootings. There was 3, let alone yesterday. Change doesn't happen overnight, and it takes more than one person to make change. By passing Jalen's law, you will be where the change starts, with students bringing guns to school. You will be where things start to change in our world. This law will be the start of the reason students feel safer at school, and parents' minds can start to be at ease with their children at school. Why not take the few extra steps and start to keep guns out of children's hands and out of schools? I went to March for Our Lives in 2018, and something one person has said was, we are done hiding, we are done being full of fear. This is the beginning of the end, from here we fight. Sadly, nothing has changed, and it's only gotten worse. Enough was enough back then. We are at the point of too much. We have to be where the change starts in the world, and we cannot wait for it just to happen. We have to be the ones that stop thinking about yourselves and start thinking about the children that have lost their lives to a gun, and start the process to keep it from happening as often as it does. We have to be where change starts.
Thank you very much. Aaron?
Hello, my name is Erin Willie. I'm 15 and I attend Great Mills High School as a freshman. On March 20th, 2018, my older sister, Jalen, was murdered in Great Mills High School. I now walk those halls, walking through the same hall where my older sister was shot every day. I have 2 classes right outside where she was murdered. Jalen was someone who I looked up to and admired. What 11-year-old wouldn't look up to their big sister and be like, that's an amazing person? The shooter who shot my older sister in the head was using his father's gun. Jalen's Law, House Bill 307, would make it so no child would have access to a gun without parental supervision. Not only will this law prevent children from getting murdered, it will also prevent suicides from happening. When the child is in crisis and they have access to the weapon, it makes it so that they're more like... When a child is in crisis and they have access to a weapon, and they don't have access to a weapon, it decreases their chances of dying significantly. Storing guns safely will prevent the number of accidental shootings that happen, because if there isn't a gun left on the counter, what child can accidentally grab it and shoot another child? Think about the amount of lives that this bill would save and pass Jalen's Law.
Thank you very much. We hear now for 2 minutes, please, from Mike Song, who's on here virtually. So, Mr. Song, please.
Thank you so much for having me. My name is Mike Song. I like to think of myself as Ethan's dad. My son, Ethan, walked into a neighbor's home January 31st, 2018. He had just gotten his braces off, and my wife had just texted me a picture of him smiling. First time I could see his teeth. And he was dead 1 hour later. All I have physically that's left of Ethan over my right shoulder in that cabinet over my shoulder is a lock of his hair that the emergency room doctor cut off and gave to us. You can see a picture of him over my other shoulder. And, you know, the mountain of pain that we've endured and the river of tears that we've cried, I know that Jalen's family, and I'm sending them all my love and strength and support, and all of the survivors of gun violence who are in this room, they know too well that it is time for change. We are working across the country. Just got back from New Mexico, where we're passing Benny's Law. We have Jalen's Law here. And I think that what we're seeing is a national movement to realize if there's kids around, you should lock guns down. That is what the NRA tells you to do. We just want accountability for that. You know, I heard a comment earlier that I wonder if it mattered or not if there was a penalty for not wearing your seatbelt. Man, if you ask 90% of the parents and anybody in this country, if I tell you this word, ticket, or they're going to say, click your seatbelt, because they know that they were going to get a ticket if they didn't buckle up their seatbelts, and that helped save 15,000 lives a year, according to the National Highway Safety Transportation people. We could save lives. We can stop so many kids from dying. This passed in Connecticut with broad bipartisan support, 127 to 16, and I know Maryland is a great state, and it's going to rise to the occasion and help keep kids safe. Safe storage will save lives. Let's all be heroes today and push this legislation forward. Thank you.
Are there questions for this panel? Certainly thank the Willies for being here today, and certainly thank both of you for courageously coming up and stepping up to the table. I know that is not easy for anyone, but particularly not easy when they're under 18. So we thank you very, very much for being here today. So that concludes those people who are here to testify in favor of House Bill 307. We have one person now who's here to testify favorable with amendments. I'm not sure. There she is. Melanie Shapiro. We're going to hear from her. Then we're going to go to panels of people who are listed as unfavorable. I understand that there are still people who are perhaps watching on or not online, but I have several people who are signed up to speak virtually unfavorably. They should just be ready that we're going to get moving with that here in a few minutes. Ms. Shapiro, please, for 2 minutes.
Thank you, Mr. Chairman, Mr. Vice Chair, members of the committee. I'm Melanie Shapiro, the Public Policy Director at the Maryland Network Against Domestic Violence. I'd like to thank Delegate Bartlett for this bill. And I think just want to point out that one of the most important parts of this bill is the title, prevention. And so I think one of the different aspects of this bill and why MNADB is here in support of the bill with an amendment is that it extends to prohibited persons, and pursuant to a final order of protection, the court shall remove and shall order the surrender of a firearm. I will repeat the same statistics that I repeat when I testify about the correlation of firearms and lethality in relation to domestic violence. The risk of homicide for women increases by 500% with the presence of a gun in the home, and the 2021 domestic violence homicide numbers were the highest they've ever been in 10 years. 76% of those deaths were caused by a firearm. Tuesday of next week, we will memorialize the victims of domestic violence homicides in 2022. 56 deaths, 75% of those were caused by a firearm. There were also, in January of 2023, 882 individuals who were ordered pursuant to a final protective order to surrender their firearms. Similarly, there were 274 orders to vacate a home, those same numbers. And so those individuals are going and staying somewhere else. And we don't know if there's a firearm in those homes. And we want to ensure that they are safely stored so that a prohibited person does not gain access to a firearm, because the highest risk of lethality for a victim of domestic violence is when they leave. And that is what a final order of protection is. It is leaving. And the importance of this legislation cannot be underestimated. We support the safe storage aspects for children. We support the aspects that will prevent homicides and suicides. And I would also like to note that the correlation between domestic violence and mass shootings, in one study, more than 2/3 of mass shootings were related to domestic violence. So it will have a positive impact there as well. For all of those reasons, we urge a favorable report with that amendment on House Bill 307.
Thank you very much. Are there questions for Ms. Shapiro? Seeing none, we thank you very much. We're now going to go to panels of people who are here to testify unfavorably on the bill. We'll start with John Jocelyn, Ari Plout, Mark Pennack, Michael Burke, Charles Watkins is on virtually, Chris Peabody is on virtually. Mr. Amsbaugh is presently breaking Maryland law, so we will not be admitting him and allowing him to testify. Mr. Plout, please begin.
Thank you. Mr. Chairman, Mr. Vice Chairman, honorable members of the committee, my name is Ari Plout. I'm here on behalf of the National Rifle Association, respectfully in opposition to House Bill 307. We have issues with the bill, but I'm going to focus on just 3 of them. We disagree with the addition of the exemption language on page 3. The current law is if youth have a certificate of firearm and hunter's safety, then they would not require parental permission to go hunting. And the bill speaks to express permission, but I don't know what that, does that mean that they would need a signed document to go hunting? It just, express permission is a little unclear. The second issue would be the tamper-resistant language is also vague terminology. We could be in violation of the law even if we would store the firearms properly, but because we don't have the right lock, this could potentially put us in violation. A lot of our members are unaware of where else the tamper-resistant is. I don't know where it is in the statute, or there's no guidance on what that actually means. And lastly, this law is duplicative. In criminal law, Article 3204, the definition of reckless endangerment states that a person, quote, may not recklessly engage in conduct that creates a substantial risk of death, of serious physical injury to another. So this law already exists if you want to charge someone with reckless endangerment. And through my research, this has been done in other jurisdictions. So thank you for the time to speak, and I urge an unfavorable report on 307.
Thank you, Mr. Chairman. Mark Pennack, President of Maryland Show Issue. Everybody's in favor of safe storage. I'm an instructor, I teach it. I encourage it at every turn. But just because that's a laudable end doesn't mean you can go about achieving that end through unconstitutional means. The Supreme Court in Heller invalidated a safe storage law of the District of Columbia, and it held that the state may not render access to a firearm for impossible or difficult for immediate self-defense. Immediate self-defense was the standard. This bill violates that in every sense of the word. You can't have an unloaded firearm separated from the ammunition and stored in a locked box and have immediate access. Second, Supreme Court held in Buren just this last year that if you're going to regulate the keeping of a firearm, you're going to have to find an historical analog dating back to 1791. There is no historical analog for this kind of statute. So I would urge this committee to seriously consider what Senator Carter did last year, and it was actually passed the Senate in Bill SB 773 and came over to this committee. And that is to encourage the use of safe storage devices by subsidizing them so that people can have a tax write-off. That would at least be effectual. That will at least encourage people to go out and buy these devices and use them. But to require a safe storage device is actually in direct conflict with existing Maryland law, which a safe storage device includes a trigger lock. Trigger lock is inadequate under this bill, and yet this bill, and thus this bill discourages it. But the trigger lock's better than nothing. So the bill has multiple legal problems. We urge an unfavorable report.
Thank you, Mr. Chairman. John Jocelyn speaking for 2A Maryland. The physician who spoke made an interesting point. He spoke of the child-resistant caps on drugs. I know of no statute in Maryland that requires the prescription drugs be locked up in the same manner parallel to the legislation before us. Further, there's no requirement that they be punished if they fail to do so. The child is nonetheless still at risk. The bill adds something interesting in this twist here. It now puts in a prohibited person, but there's an exemption when someone gains access that it was lawful entry. So you have your child who is 18, brings his friend in, is 17 years and 11 months. That was not illegal entry. You hire a workman to fix your refrigerator, not knowing that that person is a prohibited person. Potentially, you are now exposed because you didn't know and had no way of verifying whether or not that person was prohibited. It's curious that Section 4104E, which deals with evidence of negligence and evidence of contributory negligence, that entire section has been removed. I'm sorry, but to me that said we're trying to facilitate civil litigation. We are not opposed to safe storage, but we question the efficacy of this, particularly when we have a section that says if the person has a hunter safety certificate, hunter safety makes you safe with a firearm. Hunter safety does not deal with suicide. You have to give express permission, but express permission is not defined. There's a list of people who are supposed to receive the information or you have access to it. Curiously, hunter safety instructors aren't included. HQL instructors aren't included. Carry permit instructors aren't included. NRA instructors aren't included. This omission might be an accident, but it seems to me that we are more interested in discouraging firearms ownership than we are in really addressing the root cause of the problem.
Thank you, Mr. Chairman, delegates. Michael Burke out of Baltimore. I speak as a firearms instructor for most of my life, as a police officer, and as an EMT. I'm going to go backwards and first recommend an amendment to drop the first half of the proposed bill and focus entirely on suicide prevention. But I'd like to remind the panel, 988. We have an existing suicide prevention system on a national level, 988. It's not mentioned in this bill, but I would recommend that any action taken by the Secretary of Health and Mental Hygiene add that to this language. Back to the first half, as my colleagues have mentioned, this bill is full of unintended consequences and wishful thinking. Tamper-resistant locks, as mentioned, don't exist. I speak as a certified physical protection specialist. There are no such things as tamper-resistant locks. The U.S. government uses GSA standard locks on firearms, gun locks, armories. The state police uses similar. They are only valid to resist tampering for up to 15 minutes. The second statute or clause in this statute we disagree with Firearm inoperable to a child. Again, such a standard is impossible, doesn't exist. We can show you videos of 5-year-olds in what used to be the Soviet Union and Russia assembling and disassembling an AK-47, actual fully automatic machine guns. Children can do anything. We often require our children to access their own, electronics. Unlikely to gain access, there's no place on the planet you can put a firearm that a person who's on the prohibited list can't get access to it. So it's simply unenforceable. Thank you for your time.
Chris Peabody.
Good afternoon. My name is Chris Peabody. I live in Leonardtown, St. Mary's County. Jalen's murder happened in my community. It happened in the school system that my family was in at that time. It's tragic, and her murder shouldn't be forgotten or downplayed. I do request an unfavorable ruling on this bill. I don't take my stance on this lightly. I want safe firearm storage. I want less suicides of people of all ages, regardless of the method that's used. For the mental health portion of this bill, why does the suicide awareness part only focus on firearms and ignore all the other suicides? Where in the bill is the state health department guidance to schools for conflict resolution training and basic behavioral counseling? Got to get in front of the real problem and not just focus on one of the tools that's used by perpetrators. The firearm's not the root cause. The root cause is the repeat, unchecked antisocial behaviors and the repeat, unchecked emotional outbursts that are the early warning signs of violent, deadly behaviors, as well as signs of preventable suicides. The educate on the safe storage practices in the bill, it already exists. Those tools have existed for decades. They're out there. They're already paid for. Spend that money instead. Use what's out there. Spend that money instead, some of that money, on actual physical devices that will help families safely store their firearms. Provide tax credits towards safe storage equipment for the firearms owners so that they don't get caught up in a law. Drop the criminal penalties. Focus on safe storage. Focus on the education of safe storage and the resources for everyone. Focus on proactive mental health and behavioral counseling support. Thank you.
Mr. Watkins.
Yeah, I'm Charlie Watkins. I agree that firearms and ammunition needs to be secure. However, I have several concerns with this proposal. This bill leaves the meaning of secure as not likely to gain access to ammunition and firearms, which can be interpreted different ways to different people. I believe this bill needs clarification as to how firearms, etc., and ammunition should be stored differently for 15, 17, and 18-year-olds. To address an earlier question somebody brought up, as it's written, I believe this does state ammunition is to be in a secure location as well, not only separate from the locked firearm. On the bottom of page 2, I believe that's what it says. How will this bill be monitored is another question. If someone is breaking down your door and your guns and ammunition are in different and secure locations, the homeowner might not have enough time to adequately arm themselves. I am not for HB 307 as it is written today and asking for an unfavorable report. Thank you.
Mr. Carlin Weber, please. Then Ms. Mooney.
Good afternoon, members of the committee. Thank you, Chair. Thank you, Mr. Vice Chair. My name is Daniel Carlin Weber. I am a District 46 resident. I'm also a qualified handgun instructor under Maryland state law. I also do other firearms training. I am urging an unfavorable report on this bill, but I don't have objections with the lower general health article portions of this bill. And where I think there's been some error is saying that we should be doing everything in our power to force this issue. None of that has been tried yet. None of that. Guns have always been a taboo subject. And I understand, obviously, because horrible things do happen with firearms. But this focus on education has not been attended, whether it be in public school, whether it be through public service announcement campaigns driven by the state. There's been no attempt at that in any regard. And instead, the focus has been, let's find a way to imprison more people. I am a firearms instructor. I teach safe storage. I teach the current provisions under Maryland 4-104. And I make clear, even beyond the law, that people have a duty to make sure that their firearms are properly stored in a manner that fits within their lifestyle. And the problem here is what is reasonable. What sort of reasonable storage solution might fit for one family might not be the same for another's living situation. What can a family afford? Merely because they aren't able to afford a safe that's going to keep their 17-year-old out? Do they lose their ability to be able to protect themselves under the Second Amendment? No. There's real difficulties out there around this subject. It was testified to earlier. The common cable locks that are provided with firearms that are eligible devices under current law, those are inadequate under this bill. So for all of those reasons, I would urge the committee to follow through with the unfavorable report, but I do not object to the lower half of the bill. Thank you.
All right, Ms. Mooney, please.
Thank you, Chair and Vice Chair. I appreciate the moment to be able to testify as a DC project director that is Women for Gun Rights. I am also Armed Women of America state leader, and I'm a federal firearms instructor that teaches firearm safety, teaches using safes, but also teaches self-defense in the situation of your home. I agree with the second half of this bill as well when it comes to the mental health section completely, but I don't believe that this first portion is necessary. We already have in the Firearm Safety Act of 2013 addressed these issues, and we teach these in every single class, HQL or concealed carry. Any basic safety course that I teach is going to teach safety, locking your guns up, keeping them secure, away from unauthorized people, meaning children and felons. I just don't believe that this bill is written in a way that makes home safety addressed the way it needs to be. I love that I keep hearing education. Educate, not legislate. I agree, that's exactly what we need to do. I will teach any class you want to teach. I'll make videos, I'll make commercials, whatever you need. Education is important. You have to take that part and realize that we have in the gun world child safe programs, and we have Eddie Eagle with the NRA. We have all these things, but you're afraid of it. Like the gentleman before me said, so much of it's been taboo for so long. Please rethink how this is written. Keep the mental health portion of it in. I'm totally good with that, because I do believe that that's where most of our problems lie in this country. Please give an unfavorable report to House Bill 307.
Mr. Amsbaugh, are you presently in actual physical control of a motor vehicle? Or are you driving the motor vehicle? Or are you pulled over?
No, I'm sitting in my van.
2 minutes.
My kids are being loud. I'm sorry about that. So, as everyone else said, I don't disagree with the mental health portion of this. I have an issue with the fact that this bill puts myself and my family at risk, and that I don't have ready use of a loaded firearm when I see fit to defend my house and my home. I've got 3 daughters that are school age. I don't ever want anything happening to them. There's no coming together on this issue for me as long as that is left in. It's an absolute hard stop for me. And to the person that said it is only going to take seconds, you've never tried to load a firearm under duress. And I have, and I'm telling you, it's not going to be as quick as you think it is. So let's not conflate one issue with the other, and I urge an unfavorable review. Thank you.
Thank you, Mr. Chair. So I just wanted to really quick touch on, I know it was mentioned that we have reckless endangerment laws. Could you just remind me what the penalties are for that?
That's 5 years in prison. Indeed, it's been recently charged, so it's available as a a remedy.
Okay, and so the person who is charged with it and convicted would lose their gun rights because it's more than more than 2 years?
That's correct. They are
Okay.
permanently disqualified.
Okay, and then I heard you mention how the Heller case said sort of immediate self-defense. So I'm thinking after the first time we heard Jalen's Law back when it was Delegate Stein's bill, I went home and my husband and I had a really long conversation. We looked at all of our weapons. We looked at how we were storing them because we have 2 really well-behaved kids, and then we have, you know, that one
I sympathize
one
with it.
kid. And so we reworked everything. We bought, I think we spent, $800 or $1,000 on a very large safe that can fit all of our long guns. And then I bought a handgun safe that can be easily accessed. So, the problem that was mentioned with loading your firearms in a situation that's fast moving is not acceptable, essentially. So I got something where my handgun could be loaded and chambered, but secured, and only I could release it with my fingerprint. I spent maybe $400 or $500 on this. I'm blessed that I can spend this silly amount of money on these things, so I'm thankful for that. It didn't work. So it's still sitting, non-functioning in my home. I have yet to get it returned and a new one that hopefully will work. But so is that safe that I bought, that would not qualify under this bill?
Well, no, it wouldn't, because one, you are storing it loaded, and this bill requires it to be stored unloaded. I'm highly proficient with firearms, and loading under stress is always difficult, no matter how much you practice, because you can't duplicate the situation involved. So what you're talking about are the biometric quick release safes.
Yeah.
I've gone through probably 12.
Wow.
And I've yet to find one that really allows me to do a quick release.
Yeah.
Now, I don't have anybody in my household that's under 18, indeed under 21. But it is a concern because if you have to access what the Supreme Court says you have a right to do, immediate access for self-defense, that's not going to cut it.
Right. Yeah, and that's my worry. I mean, a previous bill that we had mentioned, I've received death threats. People know where I live. I've gotten letters sent to my house and stuff like that. I mean, I'm lucky to live down a bit of a lane and I have guard dogs, but quick access is really kind of the bare minimum. So hopefully they'll create better safes as we go forward that actually are quick release. Because I desperately wanted to have something like this that would be functional. It doesn't seem like it's there yet.
I couldn't agree with you more, unfortunately.
Yeah. All right. Thank you, guys.
Okay. So under the District of Columbia versus Heller, I believe, is that the case you're referring to?
Correct.
If we pass this bill, would their ruling supersede what we pass?
Oh, absolutely. And indeed, I'll quote Congressman Raskin on this in the context of the Montgomery County legislation. It makes no sense to pass legislation only to see it struck down. And whether or not there's a facial attack or simply whether it's raised as a defense or a prosecution, this bill as written will not survive judicial review.
Also, are you familiar with this? The Fifth U.S. Circuit Court of Appeals ruled last week that the Second Amendment allows people under protective orders for committing domestic violence to keep their guns?
United States versus Ramini. Yes, sir.
Would that have any application to this bill that you're aware of?
Well, it would in terms of the access to by prohibited persons, because that's a federal statute. That's Section 922A, A8, that prohibits access by such individuals. That was declared unconstitutional. And that would mean that these individuals would no longer be prohibited, which means that they would have access to firearms.
Thank you so very much.
Thank you, Mr. Chair. Gentlemen, we have heard a lot of really tragic stories today, and protecting children and protecting everyone from suicide is really important to me. But because of personal reasons, I'm also very, very concerned about personal safety, protecting individuals and families. And so I'm wondering, is there an amendment or anything you could offer that would perhaps mitigate some of the tragedies we've heard about here today, while still allowing people to have quick access in terms of self-defense?
So, Delegate, I'm a parent too. I'm a parent of 5. I get it. Believe me, I can't imagine what a parent goes through to lose a child. So I would reiterate my suggestion earlier, pass 773 that came to this committee last year and is now, I think it's 665 Senate bill. I didn't see a cross file on that bill. That would at least encourage people to buy quick release safes, however they may well function. That will at least accomplish something. Do not discourage people from buying safety devices, which every firearms dealer provides, which are like not just quick release safes, those are expensive, but trigger locks, which are far better than nothing. We basically banned the use of a trigger lock, even though it's on the roster board's list of things which are provided and are recommended by state law. Mm-hmm. That doesn't make a lick of sense. So those amendments seems to be absolutely critical.
Thank you. And I probably should have asked this of the sponsor, but it didn't occur to me until we've kind of gotten through everyone's testimony. But do you think that if this law went into effect, based on the lives that we've heard about today, the people who've been affected by gun violence, do you think that if this went into effect, we might see more if people are unable to quickly and effectively protect themselves?
So that will vary by areas. Delegate Conway, I take your point that in some neighborhoods there's a big problem with home invasions, and that's real. And people who are subject to that kind of threat are not going to obey any law this body passes because their survival trumps these considerations every time. That's why there's so much carry in Baltimore.
And if I may add, as a parent myself of 3 children and more than a dozen foster children through my house, I feel deeply for the namesake of this bill and her family. However, I would remind the committee and the delegates and sponsors, it was a crime for a teenager to walk out of his house with a handgun. It was a crime to carry a handgun onto school property. He violated more than a dozen existing federal and state statutes in the pathway to commit the offense he did. Adding this bill to punish his father would not have prevented the crime. Referring back to another woman's testimony in Sandy Hook, the woman, the mother of that killer, kept her firearms in compliance with this statute, if this statute were effective in New Jersey. He killed her, stole the key, and broke into the locked compartment where she kept the rifle that was used and the ammunition that was under lock and key. He broke the law, committing murder to get access to the firearms that he knew were there. So safe storage, I teach it as a firearms instructor, I have for decades, is about education. I would ask that we reach out to, again, the second half of this bill and invite more than 100,000 instructors across Maryland to come into the schools and teach 4 hours of firearm safety, how to handle a weapon safely, what not to do if you're a child. We teach that. We teach that in our classes. We teach that to the parents of children who are buying and getting handgun permits and buying handguns. That's something we do out of our own volition. That's NRA policy. It's the policy of other organizations that teach us how to teach firearm safety. So that's something we already do in accordance with the state bills on handgun permits and HQLs. It's already being done. It's not taught in schools. We don't teach the children in 1st grade, 5th grade, 7th grade, 11th grade what not to do. I would happily donate my time to come into any school and give a 2 or 4 hour presentation to the entire assembly on what children should not do and help educate them on these things, as well as enhance teaching suicide prevention, teaching them about 988, teaching them about peer recognition of children under stress, and referring them to an adult. These are all things we can do that aren't required by statute, but the school systems, the counties, the state system don't require it. And it wouldn't allow me to come in and teach a firearms class in most cases by policy.
Well, I really appreciate that. Thank you so much.
Delegate, if I may, in the 1990s, the Maryland House of Delegates did in fact recognize with Eddie Eagle Day in the House of Delegates. It was an official recognition, certificates were issued and so forth. That was 30 years ago. Unfortunately, the follow-through hasn't been there because it's easier to vilify the firearm than to teach education. The NRA is the leading instructing source in the entire country. No organization knows more about firearms safety and firearms instruction than the NRA. That program in an updated form is still available.
Thank you so much.
Seeing no further questions, thank you all very much. That concludes the testimony on House Bill 307, and that concludes the testimony for bills today. Members of the committee should be aware there's a possibility that we will have a voting session on Friday immediately after the session. Immediately after the session on Friday. So just be aware you have plans for maybe 11:30 or so. Just be aware that we're going to be voting probably at that point. Thank you very much.